Item 1.
Item 1, my lord. Your lordship, on 21/11/2025, directed the Controller of Accounts and DEO Baleshwar to appear in person. My lord, they have complied the dispute in question, my lord.
They have sanctioned the pension.
Yes. Pensioned and DCRG both.
Yes, they have sanctioned.
I have filed it.
Here there is delay of 2 years and eight months. So I am claiming interest in view of the judgment of that Padmanabhan.
Lordship, may kindly have a look to the affidavit I had given.
Is there any fault on his part?
No.
No, we should say not him.
Yes.
The question is to him.
Yes.
My lord, I don't think there is any. There is an intra-departmental communication there.
How he is.
My lord, he is responsible because his service was at one end and he was posted somewhere else.
Who posted it?
My lord, the government, obviously.
How can you find fault with him?
My lord, that is.
You pay reasonably. How much it will be, Mr.
But that is delay of 2 years and 8 months.
Very nominal, 2 years only. Whatever.
First 6 months you are not entitled.
Yes, I am not.
My lord,
Therefore, it is only 2 years.
my lord, your lordship may kindly appreciate that this is payment of gratuity. Gratuity always carries interest.
7%. 7%.
You will get that.
That's
What is wrong?
interest. On pension you pay.
And
Yes.
pension interest, we have already sanctioned him, my lord.
What is the?
My lord, his last pay drawn was
No, not that. Interest rate.
pension, there is no interest.
Interest you have to. That is Padmanabhan Nair.
Padmanabhan Nair.
My lord, he was last pay drawn, he has net qualifying service was,
No, I am not on arithmetics. I am not on arithmetics.
my lord, 38,000 net.
Whatever,
Yes.
whatever in you for the delay in dispersal of the pension, you are liable to pay. That's what the highest court of the country has said. Where is liberty to me to disobey the dicta of the apex court? The short grievance of the petitioner as to non-sanctioning and release of terminal benefits such as pension and DCRG
Yes.
has been largely met by the order dated.
My lord, yes. Coming to that.
So which reads as under. Next paragraph.
On, my lord,
That give that copy of the order.
the order which was passed by your lordship.
Not me.
Oh, by the order, I have annexed in that
That
compliance affidavit, I had annexed.
the short grievance of the petitioner.
That is 26.
Request. The short grievance of the petitioner related to non-sanctioning and releasing of terminal benefits such as pension, DCRG, etc.
It is 26/11.
Wide order dated 21/11/2025 had threatened the officials who were apparently at guilt, at fault, and the said order reads as under. Next paragraph. Now, learned AGA, Mr. G, appearing for the official OPs, submits that the petition has become infructuous in as much as the terminal benefits have been sanctioned. Wide order dated
26/11/2025.
26/11/2025.
Yes, that is.
Once, give that. Copies which has been which has been mentioned in the counter affidavit, compliance affidavit, but filed by OP number 3.
Yes.
This day in the open court. After serving a copy thereof on learned counsel appearing for the petitioner. First, petitioner does not dispute.
Yes.
First, next. There is force in the submission of learned counsel, Mr. Swain, that pension being not a bounty in view of Devaki Nandana Prasad versus Mishra versus State of Bihar, followed by D.S. Nakara versus Union of India, delayed payment of terminal benefits has to suffer levy of interest. More particularly in the light of apex court decision in the state of Kerala versus Padmanabhan Nair.
Year 1985 Supreme Court, page 356.
First off, learned AGA very passionately opposes levy of interest, contending that the delay happened because of intra-departmental issues and procedures, and therefore procedures. First off, this is not recognized as a ground by the apex court in any of the decisions, as a ground for denying interest. First off, no contra decision or rule is brought to my notice. First off, therefore, interest has to be paid. First off, however, the interest component may be recovered from the hearing officials in accordance with law personally. That would ensure that no loss is occasioned to the exchequer, public exchequer. Next one. In the above circumstances, this writ petition is partly allowed. First off, a writ of mandamus issues to OPs to pay to the petitioner interest at the rate of 9% per annum.
Too high.
No, 9% per annum.
Let it be 7%.
No, on what ground?
In Padmanabhan case, 12%.
Now it's
Yes,
83 it was.
Yes.
When the reserve was very high.
Yes.
Yes. 9% per annum. On the with effect from the date the petitioner completed 6 months
From the
of
date of
retirement.
Yes. He retired from service on 31/3/2020.
31/3.
31/3/2023.
110.
Yes.
With effect from 110
2023.
2023. First, the interest component may be recovered from the hearing officials of the department. Okay.
Item 55.
Next.
Item 55.
55.
In portions to the milord's order, when the principal cum secretary didn't produce the relevant documents as desired by this honorable court, so directed the jurisdictional police to ensure his attendance. In fact, they come because of the. Please pass it over. They are coming.
Pass over.
I'll make a mention.
Ask him. Or he will be in the court hall only.
Yes.
Whether we have any vacant space to keep these people in arrest in our court? Any court hall is vacant? Any room? Ask them afterwards. I will lodge them. I will not send them to the jail halls. I will put them here only. Yes. Next.
Item 2.
Regarding withdrawal of GIA, the petitioner was appointed
Withdrawal of
withdrawal of granting it.
granting it. Any notice was given to him?
Not notice was given.
Notice was
Not appeal preferred. Appeal upheld the withdrawal. Appointment is of 1993. On the ground, the Lordship will see that is page 24 or 28/8/93 was appointed. Now, granting aid was released in his favor in the year 2012. Now, he continued as such. There was a complaint that he did not have requisite percentage of marks. On that basis, they said that they have withdrawn the GIA. My two respectful submissions. If Lordship sees for withdrawal of GIA, Section 70 in the Education Act is the provision. Withdrawal of GIA is in connection with the Committee of Management or governing body, not in case of an individual. Para 21 of GIA Order 91, that says only in a case of false information or concealment of an information, GIA order can be cancelled.
read that section.
Right. First, your Lordship would see para 21 of GIA Order 1994.
Read.
Where an order has been made by the government or director, irrespective of whether such an order relates to notification of the government education institution as an aided education institution, approval of any post, eligibility of any post to receive grant aid, determination of the person who is eligible to receive grant aid against an eligible post, or any other matter on the basis of incorrect, false.
Incorrect is that only. That you did not have the percentage.
No, we have disclosed the percentage.
You have disclosed what is disclosed is incorrect. In the sense, it does not comply with the requirement, not percentage being right from. That's how division bench has said.
No, but
In one decision.
the incorrect people, let's see, if the percentage I have disclosed, which is other than my actual percentage, that will be an incorrect
No,
disclosure.
that
As your
argument
Lordship
is rejected.
As your Lordship will interpret, there is one more provision, clause about this. Clause 21, they cannot at all invoke. The reason being, since 2004, this 94 GIA is repealed. But Anup Senapati's case, Supreme Court has said that a repealed provision can never be utilized by authority for the purpose of that is there. Anup Senapati judgment is there.
Come on, show that.
That I have not got a printout of that. Still, your Lordship will one more aspect, one more aspect on fact. Lordship will see.
Because section 6.
They allowed me to improve my percentage of marks. It has reached up to 54%. But their rule says that it should be 48%. That is the requirement. They have gone wrong.
Anyway, as on the date you were appointed,
But my
you did not have.
But kindly see the order. Kindly see. The submission, the ground on which they have rejected it, page 15, my lord. Para 4 and 5. Lord, it's a case of livelihood of this person. Kindly see, by way of improvement, para 5. They have given me opportunity, I have improved up to 54.2. But now they are incorrect in saying that 54.2 is not the
Correct.
because the Lordship see a notification.
Nothing. Even after repeal,
Beg pardon?
even after repeal,
Yes.
power to rescind exists. Said the federal court, Justice, Lord Justice White of federal court.
And I'll get that judgment and this notification.
Look into it and come back.
Beg pardon?
Look into it and come back.
Yes.
Call after 2 weeks. Yes.
Item 3.
Yes, madam. Yes, madam, we have to sanction and release the area and the servant to the defense area and incremental area in favor of the petitioner. I have made a representation before the Director of Secondary Education Orissa under Annex 19, which is pending before him. Page 60.
Petition prayer is reads as under. Next one. Petitioner grieves before the writ court that his representation dated
19.
19.
19.
5/20/25, copy whereof avails at Annexure 17,
And next, sir, your lordship 19.
19. In that regard, he is pending consideration on the file of Director Secondary Education, and therefore intervention of this court is warranted. Next. Learned AGA Mr. G very fairly submits that he would instruct OP number 2 to look into the grievance of the petitioner as has been aired in the subject petition in accordance with law. If all contentions are kept open and a reasonable timeline is prescribed, first off, this is appreciable. Next paragraph, 8 minutes. Open to solicit, etc. Next.
Item 4.
May please illustrate. The petitioner, my lords, seeks to challenge Annexure 4, wherein she has been kept under suspension. The only point, my lords, which I'm extending, my lords, is since July of this year, she has been put under suspension without any reasonable cause, my lord, and no proceeding whatsoever has been initiated.
Cause is in contemplation of the proceeding.
My lords. And that,
What else is necessary?
my lords?
What else is necessary?
My lord, since July, if they're still contemplating, my lords. My contention is, if their proceeding is initiated, I'll not fall short and I'll participate. But they just for contemplating, they cannot put me, suspend me and just keep on dilly-dally over the proceeding. That is my only case.
Let them hold the inquiry immediately.
My lords.
Petitioner's short grievance is against longevity of the continuing suspension. Wide order dated 16/7/2025 in contemplation of a disciplinary proceeding under Rule 15 of OCS CCA Rules 1962. First, next paragraph. The Net Counsel for the petitioner vehemently argues that suspension puts a stigma to the employee and therefore it cannot be loosely resorted to in matters like this. First, having so contended, now she submits that if the contemplated disciplinary proceedings are initiated and accomplished within a short period, her client would be happy.
My lords, we should write that would create a...
Delete that. Next one. Learned AGA appearing for the OP submits that suspension, as ordinarily happens in matters like this, by virtue of the power available under the
Rule 12.
Rule 12 of
CCR rule.
subject rules. Subject rules. First off. Suspension is undertaken in contemplation of
Disciplinary.
the disciplinary proceeding. And therefore, till proceedings are initiated and accomplished, the petitioner has to continue in on suspension. First, having so contended, now he submits that he would instruct the disciplinary authority to initiate the proceedings on a war footing and accomplish them too. This is appreciable. First, it is also desirable that the concerned authority looks into the matter again as to whether the suspension should continue beyond 6 months. In view of decision of Apex Court in
Ajay
Chaudhary versus
Union of India.
you there.
I'll give that.
So, next one. With the above observations, this writ petition is disposed of.
Item 5.
In this case, my lord, I am challenging inaction of the video, my lord. OP number 6, in which I made a grievance that the video sanctioned money for construction of a Bhogomandap over the Gochar land, in which I, along with my family member, will be suffered if the land is to be encroached for construction of a Bhogomandap. That's why I made an application to the video to consider my application and leave some space for my passage, which is pending.
Your passage on the government land.
My lord.
Why government land should be? You should have kept your land for passage.
My lord, my land is situated in the adjacent to the government land. I have been using the said government land since long for our passage.
Now you have land, you pass on your land.
that no land is available to my land, my lord. I only passage is government land in which I can avail the government land and access the government road. Since long it was vacant, but now the BDO has sanctioned.
Yeah, I expect BDO to look into that. Petitioner in his representation dated 17/10/2025 has requested the jurisdictional BDO not to sanction amount of rupees 3 lakh for construction of Hoga Mandap for plot number 416 and plot numbers 416 and 418 of in Khata number 1083 and 1084 in Moja Sahada. First one. Though the request is wrongly termed, the essential grievance of the petitioner appears to be that no space is being allowed for the purpose of ingress and egress to his land if the construction comes up. First one. Next paragraph. Mr. G, on request, AGA, learned AGA, Mr. G, on request, accepting notice for the OPs, agrees to instruct OP number 6 to look into the grievance of the petitioner in accordance with law and in a time-bound manner. That is 3 months, 8 weeks. 8 weeks. First one, in the above circumstances and with the above observation, petition is disposed. All contentions are kept open. No stopping of construction, nothing. Yes, next.
Item 6.
I pray for my lord till taking decision the construction. Sir.
Request for any interim prayer will be disastrous and therefore rejected. Yes.
My lord, petitioner was working under education guarantee scheme, my lord. After closure of the scheme, my lord.
One second. Come here. Come now.
May I take the privilege?
Bring him here. Why he did not give the documents to? What was the reason why he was arrested? So,
Item 55.
What's your name? What is your qualification?
MA in English.
MA in English.
I did, sir.
MA in English.
I guess, sir.
Huh?
Yes, sir.
Yes, sir. Yes, sir. Please come in the front. Which is the best novel written by Shakespeare?
William Shakespeare is known as world famous
No, therefore I
poet
ask,
and
which is the best? See the question.
Othello, King Lear, Macbeth, few of the tragedy and comedy.
Say one tragedy.
Othello,
Apart from that,
King Lear.
you have said only tragedies. He has written comedies also.
Yes, sir.
Say comedy.
Comedy. Forgotten, sir.
No, as an English lecturer, you have forgotten. Then what will you teach to the children? Why you were produced here?
Your Lordship may kindly see the order dated 18/9/2025 first.
What to 18/9?
He did not comply that.
Sir.
Shakespeare has written tragedies, comedies, histories, tragicomedies.
Yes.
Correct.
And thereafter, 13/11/2025, the last one.
Next order is
13/11.
13/11. This is a institution.
Yes.
You are
He is appearing for the
You are running the institution.
Sir. Yes, sir.
Why you did not produce the requisite documents on the earlier occasions?
Sir, earlierly, another principal, he was working till 2022 June, 30th June. After that, on 1st July, I got into that post
July
of
which year?
2022, 1st July. I got into the post of principal cum secretary in that college, RGA college,
Yeah.
Radha Govindo, Anchalik
Please be seated. Sit down.
higher secondary school,
Basantu.
Hon'Ble Mayurbhanj.
Yeah.
From that day till today, I am remaining as a principal cum secretary.
That's all right. These documents came to your hands when? Now you are producing the documents or not?
Yes, sir.
You are producing.
Yes, sir.
I'm asking you, why did you not produce earlier orders?
Sir, I am not acknowledging about this matter. The previous principal, he has not communicated the thing to me.
This order is 13/11/25.
Due to
If you lie, I will send you directly to the jail from here.
no, sir, I will produce all of the document.
When are you producing?
Few of the document I have already taken
No, not few.
with myself within
When are you going to produce?
within 3 days, sir.
All right. For not producing all these days, you should go for 1 week to the jail.
No, sir, please kindly, please forgive me, excuse me. I am not aware of this. I am totally ignorant about this. Sir, please kindly, I am totally engaged with the ongoing form fill up and test exam also going on. For that reason, totally I am engaged in the office and also in my curriculum, in my
You filed.
all activities, sir.
All right. You failed the affidavit. Any case was against you? Any criminal case? Any contempt matter against you?
No, sir, I am
No
not.
case?
No.
How many years of service you have put in?
Till today, I have not faced any sort of thing in my life.
How long?
Only 2 years, sir.
Hereafter, you should scrupulously abide by the court orders.
Yes, sir.
Because I'm searching for one. I'm not happy that till I put
I am
somebody.
extremely, sir, sorry. Please excuse me.
You write a memo saying that from your side mistake occurred and hereafter it will not happen. And within 1 week you will produce all the documents.
Yes, sir.
Write that.
As your highness.
I want to put some officials in behind the
Sir,
bars.
please excuse
No,
me.
anyway,
Sir.
now it's all right. I wonder.
What I learned
Some
that
higher officials I want to take them.
what I learned while coming to that there is a because they have been vested with one lawyer who is fighting out
Mr. AP
litigants.
No
So
communication.
it's a communication gap. What I understood, my lord.
That's
It's a
right.
communication gap to the concerned principal who is in charge, the person who is in front of my lords. For that purpose. However, he is ready to submit the documents and accordingly proceed.
Sir,
One minute.
All right, I will not do anything to you. Now you are before the court. Next date, if you do not produce,
no, sir. Sir,
you bring your medicine and other things so that from here itself you will go to the right place. Okay?
Sir.
This court, while order dated 13/11/2025, had said as that. Next paragraph. Since the direction was not complied with, the court had no option than to direct arrest and detention of the person concerned for not producing the documents, which are essential for adjudication of the list at hand. First up. Next paragraph. The order having been, I will not mention police, etc. The order having been now complied with, in the sense, some of the documents have been brought and exhibited to the court and shown to the court by the principal Shri so and so, who is personally. Leave it.
Come secretary.
Sit down. Sit down. Sit down.
Principal come secretary. Principal come secretary.
Principal come secretary Shri so and so, who tenders apology and assures that within 1 week all documents would be made available. First off, he has also explained about the communication gap between himself and his counsel. First off, such things do occur, as this court has seen in several cases. First, next paragraph. In the above circumstances, call this matter in the which date? In the first week of January?
Yes.
In
With a copy to me.
That's one.
I am appearing for the respondent number 4.
I am appealing for the appellant.
Appellant.
Lordship, you indicate that with a copy to me.
Yes. What you said? In the second week of January 2026. First off, in the meanwhile, the principal Shri so and so, Company Secretary so and so, shall serve copies of all the documents on the advocates appearing for the other side. First off, he shall send some responsible official on the next date of hearing to the court, along with all the documents. You need not come. Send somebody with all the documents. That is sufficient. The service rendered by
This IIC Rasagomdapur, accompanied by this sub-inspector.
is that much. Service rendered by so and so. Police DYSP. Who are you? SP or DYSP?
She is sub-inspector. Sub-inspector.
Sub-inspector so and so is appreciated. Just next.
Interim order to continue.
Interim order to continue. Call this matter on one date. So that on that date he has to keep the documents present. January. Keep on January calendar also.
Lordship posted it to second week of January.
But the date they should.
Yes,
They have, which place you have to come from?
This is
Mayurbhanj.
How many kilometers?
It is around 200.
More than 200 kilometers.
Near about
You should know the date.
This is second week of January.
Second week of January.
16. 16. 16. All right. Okay. Next.
Item 6.
May I please, Your Lordship? My Lord, petitioner was working under EGS scheme, my Lord. After closure of the scheme, my Lord, benefit has already been extended to similarly situated person. For what matter, my Lord, Your Lordship's judgment?
No, nothing is covered.
Give that copy to him. Unless you give, I am not looking. You should give in advance. You will say covered, and if they say it is not covered.
Oh, representation disposal fees.
That's all. Covered by the same order. You have not changed the dates and other things.
No, my Lord, no, not changed. I have not changed.
The subject matter of this petition is substantially similar to the one in WPC 31306 of 2025 between Manoj Kumar Netom versus State of Odisha and others. Discovered of by this court by order dated 24/11/2025. Wherein a direction has been issued to consider the representation of the king. Interpreted. Herein it is dated 28/6/2025. Wherein a request is made as under last prayer column, page 33. Next one. In the above circumstances, petition is disposed of 8 weeks. Solicit.
Item 7.
Item 7 made, please, my lord. The petitioner challenges the demands made under Odisha Irrigation Act in respect of the groundwater of
This is that matter which was argued by my seniors.
These are similar matters, my lord. They were posted to
MCLs.
MCL method.
Let it be tagged with that, so that's
what.
Yes, yeah.
Issue notice Learned AGA, Mr. Lenka is requested to accept notice for OPs, all OPs.
My lord, all
OPs. Call this matter along with the WP number
21153
of 25.
25. On 19th one,
Whichever date it will
My lord.
come. Okay. That day you should be ready.
My lords,
Okay. No time will be granted.
my lord.
Yes.
Entry models as in the other cases. My lord.
Entry model.
No court.
Learned counsel for the petitioner submits that in similar two cases, entry model has been accorded by this court, and therefore the same benefit should be extended to his claim. First off, there is force in this submission. Next paragraph. In the above circumstances, in terms of the application number so and so is disposed of, staying the coercive action pursuant to impugn the order.
Going to demand Annexure 8. Annexure 8.
Demand. Till further orders.
Item 8.
Next. 8.
My lord, I am from BC Barampur, my lord, and I am challenging the annexure 10, my lord. In the annexure 10, due to non-availability of record, bills cannot be sanctioned. The bills regarding the guest lecturer, remuneration of guest lecturer amounting rupees 90,800, my lord. Previously, principal sent letter regarding the sanction of the bill, my lord, as per annexure 4. Now, as per annexure 10, they have rejected, cannot be sanctioned, issued letter, my lord.
He accepts notice on request of the court for OP number 1 and 1 only 1 and 2.
1 and 2, my lord. 1 and
Notice to
sanction.
notice to 3. Okay.
Item 9.
Same.
Pardon, my lord. Item 7, the connected matter is also the same. There are two matters in
Yes, yes, same order. Yes.
Item 9 is this is my second round litigation. My RSA benefit has been rejected. In identical cases, your lordship has issued notice. Kindly check.
Notice
9 and 11, similar.
9 and 11. Notice. G requested to accept notice for OPs. Call along with W.
Along with all connected, I have given the number.
Okay.
Item 10.
Yes.
The petitioner is working as an assistant teacher in a high school. So his claim is for arrear pay, which has not been paid while he was working in untrained scale of pay.
Where is your representation?
And it's a 13-year lordship. It's at page of 59.
Petition payer reads as under. First off, counsel for the petitioner draws attention of the court to the representation dated 16/11/2024 at Annexure 13, which is in the vernacular rule. First off, he submits that if a direction is issued for considering the subject representation in accordance with law and in a time-bound manner, he is trying to be satisfied. What to
Keeping in view Annexure 12, similar
keeping in view Annexure 12. First off, no. Mr. Learned AGA, Mr. G very fairly agrees that the subject representation should meet like its fate at the hands of
OP number 1, your lordship.
OP number 1.
My lords.
OP number 1 in a normative person. First off, however, he caveats that all contentions should be kept open. With this, learned counsel for the petitioner confidence. Next, statements. Solicit.
I'm sorry, it's OP number 3, your lordship.
OP number 3.
My lords.
Yes.
I'm grateful.
Item 11 has been adjourned. Item 12.
Relating to block grant pension scheme matter, you also in identical matter issue notice and take the matter along with this matter.
They have been granted.
Matter. All three are state matter. All of which are state.
What you have done in that? You there? Only notice.
No.
Notice. Follow along. Next.
Item 13.
May I please, your lordship. The
Yes.
petitioner before your lordship is the destitute and wife of deceased employee. approach this on
Family pension is not paid to you.
yes, Your Lordship.
Where is
Since
the
the
representation?
representation is at Annexure 3 series page 27 and OP number 3 is to take decision, Your Lordship.
Grievance of the petitioner is as to non-sanctioning and releasing of the terminal benefit. No, family pension and other benefits. The husband having died, Mr. Guru Gajaraj Das having died when?
Your Lordship, the husband of the petitioner
Died in the year
in the year 1972.
17. First off. The counsel for the petitioner draws attention of the court to the representation dated 9/6/2025. A copy whereof avails at Annexure 3 series. Made to the Director of School and Mass Education, Government of Orissa, Bhubaneswar. In this connection. That is rejected.
No, Your Lordship, that is still pending. The thing remains, Your Lordship, since 1998.
The subject representation is considered, justice would be made to his client.
Director of designation may be changed, my lord. The director of elementary education is
that's
in
true.
place of in place of school and mass education. Director of elementary education, the appropriate parties, my lord.
Change that.
Lordship.
Leave of the court in the
Lordship.
Petitioner is permitted to amend OP number 2, description of OP number 2 as district director of
Elementary education.
No, Your Lordship, representation is to be changed. In the cause title, it's right, Your Lordship.
It is file fresh representation, my lord. It will be better.
Then give a representation.
Lordship.
Why when they give representation? If you are not the authority, you should send it to Lenka. Lenka, if he is not the authority, will send it to G.
Lordship.
That is the good governance.
In fact, Your Lordship, copy has also been communicated to District Education Officer as well as Block Education Officer.
To both?
Yes.
DU was also?
Yes, Lordship.
All right, sir. No, need not be sent again, once again.
Sir.
Yeah.
And BO is the
Learned AG, ASC, Mr. Sen, opposes the petition contending that the representation is given to the wrong authority and therefore that authority cannot take the decision. First off, he also adds that if a new representation is given explaining the delay, there would be no difficulty for consideration of the same in accordance with law if all contentions are kept open. Should all contentions be kept open? First, counsel for the petitioner is agreeable with this proposal. Next one, if the above observations petition is put up, if a new application for representation is submitted, supported by all documents, the same shall be disposed of within an outer limit of 3 months. In that connection, all contentions are kept open. Now no cause. Open to solicit.
Next, Your Lordship, since 98, they are communicating to each other, Your Lordship. Block Development Officer, District Education Officer.
Next level, it will happen.
Lordship. Obliged, Lordship.
Yes.
Item 14.
May I please, Lordship? My Lord, in this case, the petitioner praying for extending the pensioner benefits similar to item 12, my Lord.
Item 12.
My Lord.
Block grant pension.
Subject matter of this petition is substantially similar to one in WP number. There notice is issued.
Yes.
Or disposed of.
No.
Notice. All right. Issue notice. ASC accepts notice for 1, 2, 3, 4. 1, 2, 3, 4. Call along with the WP 12. Next.
Item 15.
Go to first reading. Issue emergent notice. Returnable within 3 weeks. Yes.
Item 16.
Here the petitioner,
Jacob.
ago, but now I am covered by the government finance department resolution annexure 2, which says, my lord, that the school attendant who have been conferred with the temporary status, they have been regularized against the vacant group D post. And accordingly, my name was recommended by latest mala, page 49, annexure 7.
Any rejection now?
No. Page 47.
Consider the representation.
Yes.
For regularization.
Keeping in view the finance department circular as well as the judgment, my lord.
That resolution dated?
Resolution at 4/9/2012, annexure 2. And the recommendation last, my lord, annexure 7, page 49. Against the 47 vacancy, my name finds place at serial number 15.
Dated
8 July 2025.
Representation?
Representation annexure 8 dated 8/10/2025. Before the OP number, my collector is the OP number. OP number 3.
That recommendation annexure?
Annexure minus 7.
7 million.
Page 49. By the OP number 4 to the OP number 2.
Right now. All government?
All government.
The short grievance of the petitioner is as to non-consideration of his representation dated 8/10/2025, a copy whereof avails at annexure A8, wherein he has sought for regularization of his survey in terms of government resolution dated 4/9/2012 at annexure 2, and in the light of the recommendation made by OP number 4 on 8/7/2025 to OP number 2 at annexure 7. First, non-consideration of representation offends Article 350 of the Constitution of India, argues counsel for the petitioner. First, learned ASC appearing for the OPs in all fairness submits that he would instruct OP number 3. OP number 3 to look into the grievance of the petitioner within a reasonable time, keeping in view the government resolution and also the recommendation mentioned above.
As well as the judgment.
At this stage, counsel for the petitioner rightly submits that the claim has to be considered in the light of apex court decision in Shripad.
Shripad, and your lordship judgment in WA number 5857.
That considers all the judgment.
Yes. In the prayer portion, I have mentioned all the judgment.
In the light of decisions mentioned in the representation dated 9/11/2025.
9/10 million. Sorry, 8/10. 8/10.
No, you mentioned 9/11 at the, kindly come to page number 20. 8/10/25. You're right. There are two representations.
No,
9/11 is also there.
9/11.
Anyway, next slide. 8 weeks. You open to solicit sciences and all pretensions kept up. Next.
Item 17.
Please, your lordship. The petitioner
The delay will be viewed very serious in the next level of the legal battle. Yes.
The petitioner is working as a lecturer in a college, and he joined in the college in the year 1999. In the year 1999. Thereafter, as per his seniority, he was promoted to the post of principal in the year 2011 by annexure 2. Thereafter, he, due to his illness, he was on leave, and after in the year 2016, when he resigned in the college, he was not allowed to resign. Hence, he approached this Hon'Ble court, and this Hon'Ble court, after hearing, direct the opposite party number 1, that is the director higher education, to interfere into the matter and take a decision. Thereafter, by annexure 4, the director has taken a decision and passed an order for allowing the petitioner to resign in the college. After resign in the college.
So he allowed your request. He recommended your request.
Madam.
Who recommended?
The director higher education, madam.
Recommendation dated? That OP number?
OP number 1, my lord.
No, who recommended? OP number 1.
As per direction of this honorable court,
Consider that one.
OP number 1 passed an order
Saying
that he should be rejoined in the college.
re-engaged in the college.
Re-engaged in the college, and that order was complete, and he allowed to rejoin, but not in the post of principal, and he was also not allowed to get his salary as his junior.
Take note. Emergency. Next.
Item 18.
Well, it may be listed in the fresh admission list.
No, you can't do that. What's the procedure? Yes. Emergency notice. Yes.
Here, the petitioner was initially appointed as a lecturer, and after the college became aided, he was allowed to, being the senior most staff, he was allowed to continue as principal in charge cum secretary of the institution in the way back in 2011.
You seek reinstatement?
No, already my reinstatement order has been passed after acquittal in my vigilance case, and that was stayed by this court in another petition that is pending. Now, my lord, the ex-principal, who was my successor, he, my lord, committed serious financial irregularity during his period when I was out of the principal. For that, my lord, audit was conducted. Audit report clearly indicates that due to the non-production record by the other principal, the period from so on so period.
Take notice.
Yes.
We'll now along with that WP.
Yes. Now, Annexure 10. Now, the government, OP number 1, directed the director to initiate proceeding against me, my lord. That is, I am challenging Annexure 10.
No, that we have to look into. Once that is done,
That's
like notice.
Only one submission, my lord. Annexure 10, the impugn order has been passed by the government basing on the audit report submitted by the local fund audit officer, my lord. Our audit officer will kindly say Annexure 8, one paragraph, my lord. Page 84.
Which paragraph?
84, last paragraph.
Misappropriation of cash, etc. is mentioned.
No, that is not correct. Just kindly see. The local authority was asked to through audit of objection memo number so and so for production of PMS acquittance roll in support of the payment, sanction order, and other relevant record for audit for verification. But the local authority has failed to produce the aforesaid document before the audit verification. From the charge list, it was ascertained Kanan Vihari Patnaik, the present petitioner, ex-principal, has handed over the stipend file and voucher file to Sri Vihari Mishra principal on 22/9/15. The principal has not, the other principal has not submitted any reply in this connection. See, Vihari Mishra is fully responsible for such non-production of record and register as he has taken from charges from the Kanan Vihari Patnaik ex-principal. That is the finding of the audit officer. Because of the other principal could not produce the record, deliberately could not produce the record. Now, Annexure 10, the proceeding was directed to be initiated against me, my lord. I have handed over all the charges, including the file. I have that is also available at page, my lord. I have page Annexure 4, page 27, 26, my lord. I mean, since 22/9, when I out from the
yes, brother, what is his fault?
No,
and they would have recorded a finding. Yes, that he has given entire file. The other principal, so you can proceed against him, not against
he is also, Lordship can to page 90, my lord.
Yes.
He is also there. Page petition is there, and he is
yes.
Lordship Vihari Mishra is also there.
But I am not.
The audit party says the records are with other principal. And they say he has handed it all to them. Matter for a stay. Issue emergency notice.
No, what responsibility he have, my lord, that has been reflected in the government order, my lord.
You can't proceed for those who have already done their job.
Scholarship amount
requires examination.
Lordship, scholarship amount for SC students, my lord. That has been misappropriated, my lord.
Whoever. What is his fault?
He is the principal, my lord. He has to explain that how the amount has been given to the beneficiary.
Yes, he is requested to serve notice for the office, first of counsel for the petitioner class attention to application in IA number so and so for the brief. First of he draws the attention of the court to the findings of the audit party.
The audit officer, district audit officer, local audit.
Wherein fault is laid at the threshold of other principal, to whom petitioner has already handed the records in question. First of, therefore, a prima facie case is made out for granting reprieve. First of, next paragraph. In the above circumstances, application having been favored All coercive proceedings against the petitioner hearing are kept in suspended animation till next date of hearing.
Notice to my lord, opinion number 6.
So far the petitioner is concerned.
Yes,
Another
only petitioner.
Another petitioner. Right.
The private party, opinion number 7.
Proceedings against others are not stayed. OP number 7, private notice, emergent notice.
Right.
Yes.
Item 19.
19. One sentence you have to submit. Learned AAC is right in telling the court that no proceedings can be stayed against others. Or that will structure it. Yes.
The claim of the petition is well covered with the order passed under Annexure 7, my lord, with regard to the
ORSP.
promotion to the IACT case, my lord. And it has been decided by the Honorable Court. May I submit my highly face representation with the authority that will take into consideration in the light of the order passed by the Honorable under Annexure 7.
Petition prayer reads as under. Where is your prayer for?
Prayer for promotion to the IACT.
It's a lengthy prayer. Yes. It's a bit lengthy prayer.
Yes.
But makes sense. First of all, counsel for the petitioner submits that his client is entitled to benefit of coordinate bench order dated 10/7/2025, rendered in WPC 13898 of 2021 between Vinod Chandra Das versus State of Odisha. First of all. However, learned ASC, Mr. Sen, accepting notice for the OP, supposes the petition contending that for seeking a writ of mandamus, a representation is a must. First, in support of that, he quotes the treatise, writ jurisdiction under the Constitution by B.L. Hansarya, Justice B.L. Hansarya. First of all, there is force in this submission. In retort, counsel for the petitioner submits that his client would make a representation within 2 weeks, and if a direction is issued to consider the same within a reasonable time, justice would be made. First of all, this is key. Next one, in the above 2 weeks for filing object representation, 8 weeks for consideration. Open to solicit. All contentions can go. Next.
Item 20.
Both are same.
Both are.
Next.
My petitioner mother has been died in 2015. He has applied for rehabilitation assistance, and he is appointed in 2019, and merit list will be prepared. He is selected in 44, serial number 44. Thereafter, not appointed in 2025. He has been appointed in the Group D post.
In which post he should have been? In which post he should have been given?
Group D post, my lord. At the time of the death of my mother, I am a graduate, my lord. Similar matter, Lordship has issued notice.
But your Lordship, the Rehabilitation Assistance Rule 1990 that promulgated by the state government, the sole aim and object of the rule is that to save the family from distress at the time of death of the breadwinner. So there is a question of no choice. He has been given appointment. Already.
The rules say, I read the other day.
Yes.
It can be to the higher post also, depending upon quality.
Yes, ma'am.
Not very higher.
That was subsequently.
We have made the rule also.
Yes.
Then no follow that.
Same order.
Anyway, call this matter, issue emergent notice, like the accept notice for the OPs, call along with WP number. We'll put all those matters and dispose of one stroke of pen.
Yes.
Yes.
Item 21.
That
I am the
third week of January.
my lord. I am
Along
the
with WPs.
my lord. I am the senior most lecturer of the petitioner institution. I was the principal in charge and
Kamalakanta Das.
no.
The ruling which you have cited is page 13. Kamalakanta Das.
Yes.
Any representation is given?
Given.
Where is that? They have rejected it now.
No, they have not rejected.
Annexure 10?
That Annexure 10, in the meantime, one deputy has been deployed in the petitioner's institution that is drawing a salary from one Salapur college, and he is coming to the petitioner's institution and
take notice.
Yes.
Notice.
Interim, no.
Any make out some case.
The institution is suffering, my lord.
Huh?
The institution is suffering in one leg is in one college and another leg in another institution. And it is irregular, and we are facing a lot of problems. Regular, if I have not approved to continue, then regular principal should be deployed. Otherwise, a lot of problems
Administrative problems
are creating.
I will issue emergent notice. We'll call this in last week of December.
He is coming from Cuttack today, and he is also serving in Salapur College and also in their college.
I'll take instruction.
They take instruction, but he is saying some genuine difficulty. What is the interim prayer you have sought for, sir?
Let me allow to continue without any financial power and to only manage the institution. Because
on in-charge basis.
In-charge basis.
Issue emergent notice. AG is requested to accept notice for 1, 2, 3, 4, 5. Emergent notice to 6. Next, an application supported by an affidavit in IN number so and so is filed, seeking a short reprieve to the effect that the petitioner should be permitted to go to the prostrator. Continue in the office of
Principal.
Office of Principal of the institution concerned on in-charge basis till a regular appointment is made. First off, he highlights the difficulties as to the absence of a in-charge person in the institution, where the housekeeping activities have to be maintained. Activities like housekeeping have to be maintained. First off, learned EGA Mr. Lenka opposed the application, saying that the grant of a reprieve would amount to granting the main prayer itself. First off. However, he agrees with the view of the court that some interim arrangement may be permitted without giving power to take any policy decisions. First, this is appreciable. Next paragraph. In the above circumstances, the petitioner is permitted to continue in the office of the principal on in-charge basis till next day. Next.
Item 22.
22 because I am the caveat. Not sure. Yes, solved the copy on last night. I have said Spencer also may take up next week.
Next week will do that.
There is no issue of next week. Only the impugned order under Annexure 5 passed without jurisdiction. A person who has passed the order, he has got no jurisdiction.
But the caveat is there.
Caveat by the private opposite party.
Yes.
Yes,
we have to do.
Yes, my lord. Because the institution will suffer. If the institution cannot run, the financial power has been withdrawn.
Call this matter on Tuesday. In the meanwhile, issue emergent notice. Will issue emergent notice? Issue emergent notice. He is requested to accept notice for 1 to 5. 1 to 5.
6, my friend is appearing.
6 has entered caveat to his counsel. Registered to print his name, counsel's name. First, in view of pleaded urgency, call this matter on Wednesday. Okay.
Can the status quo be maintained till order of status quo? I am not.
No, that also is an entry order. Next.
Item 23.
May please.
Item number 23 here, the petitioner runs a ultrasound clinic. In order to run the machine, he requires two registration, one under the Clinical Establishment Act, the other one under the PC-PNDT Act. He obtained both the registrations are valid. Out of nowhere, in April, they conducted a team without disclosing their identity, conducted an inspection. In the inspection, they sealed the machine in April 2025. After sealed the ultrasound machine, while the patients were being treated and everything. Thereafter, they issued me a show cause in the month of May 2025. I replied those show cause notice within the stipulation time, that is 7 days, in May itself. As on date, no decision has been taken on that particular notice. My ultrasound clinic is shut. Now, the difficulty is, the show cause notice itself and the inspection are challenged on two grounds. One, the person who has issued the notice does not have jurisdiction. Second, the power of seal and seizure, which has been prescribed under Section 30 of the Act, is not applicable in as much as the sealing of a machine is only required if they need some information out of that machine. So in order to protect that machine, they need to seal it. The allegations made in the show cause notice are qua the doctors, the registration certificate of the doctor performing the machine. Not with regard to machine.
With regard to records.
Nothing. The records are offline records. Those are available.
How long you want to keep it in a suspended animation? Machine will go wrong. That will go mad.
I have no instruction, Your Lordship.
No, you release that machine.
Let me take
issue emergent notice. There is one similar matter which Shashwat Patnaik argued. Bring that judgment.
I will.
Yes. Issue emergent notice. OP is EGA, Mr. Lenka is requested to accept notice for 1 and 2. First off, in view of pleaded emergency, call this matter on 9/1/2020 in the second week of January 2026.
I vowed on so only difficulties.
No, how? All these days you are keeping quiet and no other person.
That is them.
We'll have it that one. There we have granted relief to the in identical circumstances, which we had argued. Yes.
Item 24.
May I please, Lords? In this case, my limited grievance, the petitioner, while working as a lecturer in English, he was put under suspension some periods, but so far as the substance allowance is concerned, it was not extended to him. Only my grievance is for that period, the substance allowance. I made
any representation?
No, I have not, but I have approved, but the reference I have not. Yes.
Short grievance of the petitioner is as to non-payment of subsistence allowance during the spells of suspension. First off, counsel for the petitioner vehemently argues that non-payment of subsistence allowance is a serious thing, in as much as the same is the property of the citizen and therefore enjoys protection under Article 300 capital A of the Constitution of India, as expensively interpreted by the Apex Court in KT Plantation for the state of Karnataka. First off, next paragraph. Learned AGA, Mr. Lenka, on request appearing for the OPs, OP number 1 and 2, notice to OP number 3 having been dispensed with, submits that if petitioner gives a representation producing all evidentiary material, there would be no difficulty for considering the same in accordance with law at the hands of appropriate authority. First off, with this proposal, counsel for the petitioner is agreed. Next one. In the above circumstances, petition is disposed of, reserving liberty to the petitioner to make the representation within 2 weeks. And if one is made, decision thereon shall be taken within 2 weeks next following. All contentions can open. It is open to solicit. Next.
Item 25.
Petitioner's transfer was held on the recommendation of the MP MLA manual. And
covered by judgment, Mr. Lenka will allow this matter.
No. Here, my lord, on the ground, he was appointed, your lordship, see the final order at page 27, second para. No, your lordship, not MPML.
Earlier I have Earlier I have approached this honorable court, my lord. Your lordship, can I have a glance to page 16 and except 3, my lord.
16.
My lord. Last, the transfer has been made on the basis of recommendation so received from honorable MP and MLA of the Naigaon district.
No, your lordship, see the final order.
Where is that final order?
That is at page 25.
25.
I'll
Thereafter, approach your lordship.
Wait.
Thereafter, I have approached your lordship. Your lordship has directed me to approach the DU. I have filed a representation there. And in the representation was rejected, and on the ground that I have not appointed as a BLO.
BLO, yes. Page 27, second para.
My lord, the issue.
Please wait. As per letter number so-and-so, dated so-and-so, the Tahsildar Aero Ganja, the Padma Behra has never been appointed as a BLO through postal and to proposal submitted in favor of him. On that ground, earlier he had approached your lordship, and your lordship directed to consider.
Nothing. It is not on that ground at all.
My lord, your lordship, your lordship can have annexed to 3. My transfer was made in the middle of the sessions and on the recommendation of the MP and MLA. I have approached this honorable court, and your lordship has directed me to.
That is not the ground.
Not the ground, my lord. But in the middle of the sessions, my lord, he has transferred me, my lord. That is my ground one. And in the meantime, your lordship has already passed that judgment, my lord.
You have been relieved now?
No, my lord. I am continuing. I have only, your lordship has 3 months. The academic section is now rest, my lord. Let me continue 3 months also.
Last day, your lordship has passed a judgment. Continue in some cases up to mechanism that your lordship can see that.
After that, you will
Yes, sir.
you will comply with the transfer order.
Yes. Any fresh order will be issued, I will complain.
Then I will dismiss the petition.
No, yes, ma'am. Sorry, madam. I could not follow.
Counsel, for the challenge is to the transfer order, which is affirmed on the representation by another order dated 26/11/2023. First one. Counsel for the petitioner submits that if he is displaced after the expiry of the academic year, present academic year, he would go and report at the transferred place. First one. Next paragraph. Place. First one. He pleads certain difficulties which the apex court recognized in a sense in Varadhara versus State of Karnataka. First one. Next paragraph. Learned counsel AGA appearing for the OPs vehemently opposes the petition, contending that the teachers are also civil servants and no civil servant is exempt from transfer. First off. Having so said, he reluctantly agrees with the suggestion of this court that the petitioner would be continued in the same place, provided that he joins the transferred place in the next academic year. First one. This is appreciable. Next paragraph. In view of the above, petition is disposed of, keeping the impugned order in suspended animation till the expiry of this academic year. First, thereafter, petitioner shall peaceably comply with the transfer order, failing which he may be dismissed from service. Okay. Next.
Item 26.
Yeah, please, madam. I'm checking.
I know, that last line message.
Wait, suppose if you do not comply? If you comply, where is the problem? I'm not saying that you should hang it to the nearest tree.
That is what.
No, that is the way. There are judgment to that effect. Those who do not comply with transfer order should be removed from service. Shall be removed from service. Okay. Next. Otherwise, court orders will not be implemented. Everybody will take court for granted that I am against that. Court is a serious place. It is serious place for judges. It is serious place for litigants. It is serious place for lawyers. Yes.
Yeah, please, madam. In this case, I am challenging the order of rejection. In similar cases, you'll also issue notice, madam.
See, appeal is pending, madam. That is covered by.
Appeal is pending.
Yes.
In this case, no, in similar cases.
In this matter, appeal, no, that appeal is pending there.
The cause of action arises that appeal, man. Hemanta Kumar Chotra case.
No, my dear, in similar cases, notice has been issued.
This case is not. Bindu Sagar summon to try.
This was issued.
Notice for
In similar cases, notice has been issued.
issue notice. Call along with we accept notice for one.
Item 27.
Please, my lord. This similar notice has been issued, part of financial benefit under placement rules 2014.
Amendment petition.
Allow it. Please second.
Amendment application is there.
Yes. Amendment to the prayer portion.
Prayer person, the fast prayer. Your lordship has noted in that order.
But your lordship.
First prayer has become
because that has been adjudicated.
same order.
My lord.
Same order.
Correct.
Call along with.
Item
Yes.
28.
There were some vacant lands in the Burger Station Road. The Special Planning Authority was given those lands by the state government under a scheme called Site and Services Scheme. Lands were allotted to the present petitioners. This batch is before your lordship. They were granted permission by the Special Planning Authority to construct the house with the permission. Permission I have also given. Constructions has been made. Now, my lord, they say those constructions are illegal.
On what ground?
No ground has been set. No order has been passed. But they are coming and saying that your construction is illegal, you have to remove vacate this place.
Where is the order?
My lord, there is no order. They are not.
You tell them they are legal. They are orally telling they are illegal.
Yes.
You orally tell them they are legal.
My lord, your lordship may kindly see, physical possession has been given, page 9.
No, that's all right. Where is the cause of action?
Well, cause of action is they are putting a mark and saying that these houses will be demolished.
You remove the mark. Where is that mark?
Well, that is my government.
That makes no sense.
Well, this is all going on in Burger Town. They are not giving notice, nothing. Mike announcement, demolition next day. This is going on in Burger Man.
Is it true?
And
Lord,
batch
to
of
that
petitions
effect,
are being
I don't have any document so far the REIT is concerned. This is
Well,
all solution.
Trust is the authority and Burger Municipality. State.
You take emergent notice.
Yes, ma'am.
Let them come and say
Yes, ma'am.
what they want to read.
Yes. Well, I'll take to OP number 2 and 5.
Accept notice for OP number 1, 1, 3, 2.
1, 3 and 4.
3 and 4. Emergent notice to the rest.
2 and 5.
Yes. The rest is 2 and 5.
Well, I have prayed that no coercive action be taken. Well, if they demolish, I will know
The
that.
application for inquiries will be considered on the next date of hearing of the service next.
May I pray one thing? This batch has come. One restriction has been left out. If you're not
All this, sir. Push it to Mali. Yes.
Item 29.
Or we can do one thing. Suppose if you agree, you come after we can say no action shall be taken without giving an opportunity of hearing to the petitioner. That
Opportunity of hearing this can be done.
Yes.
Because there is no order.
Therefore, I am suggesting is, I will make observation. The petitioner has not produced any material to show that his houses are being demolished, their houses are being demolished, first off. However, he need not have the apprehension of demolition in as much as without hearing such things will not be done.
Yes, ma'am. Yes.
Right.
But no, that will be the best order I can take. Because ultimately your lordship will be passing that only.
In all these cases, the apprehension is that the jurisdictional OPs would come all of a sudden and undertake demolition of the existing structures belonging to the petition. First off. Though pleadings have been made to this effect, no evidentiary material in milligrams is produced in support thereof. First. learned senior advocate appearing for the petitioner submits that such instances of instantaneous demolitions are there, and therefore the court should intervene. Next paragraph. Learned AGA Mr. Mohanty appearing for 1, 3, and 4 submits that ordinarily the state and its instrumentalities will not undertake demolition of structures without due process of law, and therefore without due process of law, such as issuance of show cause notice, hearing, etc. And therefore, the petitions are premature. Person. I agree with this view. Person. In the above circumstances, petitions are disposed of. That no coercive action, that the petitioner shall not have the apprehension of any coercive action sans a due process of law. First, if any action is being taken, it is open to them to approach the court on the fresh cause of action. Okay.
With your Lordship's permission, may I say one more line? Your Lordship may say they must give an opportunity of hearing before any.
To send a copy of this order to OP numbers 2.
All the opposite parties.
Well, they represent
2 and 5.
OP numbers 2 and 5. 2 and 5. So that they would not take any coercive action without following law.
But if the other matter, if your Lordship may call and dispose of, that will also do.
Yes.
Urgent copy.
Item 29.
29, your Lordship, modification of the order. 1 day 6 matters were listed. All those matters were covered. 4 were corrected, your Lordship. This is in respect of date and case number. I have also marked it in the pencil, but I'm not wrong.
What is to be rectified?
My lord, that is
one copy of IA may be solved upon us.
I have already got it.
You will not.
My lord,
for such silly things, you should never say no.
Probably some computer error at that. Otherwise, it would have not.
Counsel for the petitioner has moved this application seeking rectification of clerical mistakes in the judgment. First one, mistakes indicated to be rectified and free copy of the judgment should be handed if applied for. Court regrets its mistake. Yeah. I disposed of. Just look into problem.
Item 30? No.
Item 30, I am for the last connected item, Lordship.
Yeah.
This is, with apology, my lord, this is that matter where the vacancies of teachers, your Lordship wanted to know the positions and what steps we have taken. That matter, my lord. That matter, while adjudicating the dispute, my lord, your Lordship, last occasion, my friend Mr. Das, he has referred to Section 26 of the Right to Children to Free and Compulsory Education Act 2009, my lord. That speaks, my lord, the filling up vacancies of teachers.
Read which schedule it is?
No.
It's separate section.
It is separate. My lord, the appointing authority in relation to a school established, owned, controlled, and substantially financed by funds provided directly, indirectly by the appropriate government or by local body, local authority, shall ensure that the vacancy of teacher in a school under its control shall not exceed 10% of the total sanctioned strength.
So at no point of time vacancy
It should not be-
cannot be more than 10%.
More than 10%. That is the central,
Calculation.
my lord, that is the central act, my lord. My lord, in so far as elementary education is concerned, it is meant for elementary education. My data is, my lord, Lordship, we have got in the state, my lord, please. Huh?
Passover. Passover.
No, Passover Paroni. I had different cases in
Passover. Another
court number 20. I had another engagement.
Because he says it.
I'm placing this.
No, one Passover.
Yes. No, the Passover. Yes, next.
Please. My lord, total number of elementary schools in the state is primary school is 26,454. Upper primary school is 14,888. Total comes to 41,000.
8,000?
My lord,
Upper primary.
14,888. 14,888. Primary education is 26,454.
Yes.
My lord, total comes to
40,000, 41,000 order.
342.
41,340.
342 schools. Total sanctioned strength of teachers is 1,35,656.
The sanction strength.
Sanction strength.
Sanction strength is 1,35,000. Yield some place to the officer. Somebody should yield place. Suppose if you go to her office and if she does not offer the chair, what you will feel? Think they give, some youngster should give place.
It is there.
Yes.
I had asked her to
sit down. There are officers.
Help me in calculating, etc.
Yes. Sanction strength is
1,35,656.
656,
my lord.
What is the working strength?
Working strength is by way of junior teacher and schematic, my lord, and different schemes, my lord. They are on 1,32,099. There are vacancies, my lord. There is on base level vacancies is very limited, my lord. And after this government took over, we have filled up 13,416 junior teachers.
How many vacancies are remaining as on this day? What your government did, we are not on that at all.
My lord.
What is the extent? See, read section 26 again.
It is 10%
of
10% of the total sanction strength.
No, for each school.
My lord.
If otherwise, suppose you don't appoint any teacher to a few schools.
No.
All this one.
My lord, every year.
School is the focal point.
Yes, my lord. Every year, my lord, rationalization is going on. And according to that rationalization, we are supplying teachers to that, appointing teachers.
No.
So far as
how many schools? Your data should be school specific.
My lord.
You give that data, then we'll decide.
My lord, I'll bring that.
Suppose otherwise, if we agree with your contention, thousands of schools can be left without one appointment also. And you will say total number of the teachers. Sanction strength.
Yes.
Less than 10%. No, that cannot be.
I'll bring that again. Then.
You bring that data.
Yes.
So for connected matter, Lordship, last item WPC 31585/2025. That's related to colleges, Lordship. My learning seniors.
One after another will go, please.
Yes.
One after another.
My lords, if the honorable court permits, my lords, as far as the articulation from my learned senior colleague suggests the sanction strength is 1,35,656.
Correct.
For elementary education. But my lords, they have conducted a minutes of meeting, and my lords, it is quintessential that total requirement of elementary teachers as per the RT norms is 1,99,685.
What did you get that?
Yes, I have filed an
What did you give me?
I have already given I have filed an intervention application. IA for intervention.
Where are you first?
Intervention application.
You copy.
Yes,
on what basis you have where from you have got the statistics?
Yes, my lords, they have conducted a minutes of meeting. on dated 2/8/2025.
Mr. G, have that copy also.
Give me, I'll
Give one more
confront
copy.
them. I'll confront them.
Give one more copy. Call this matter on.
Give me some more time because it will take
16-1.
16-1, my lord.
16.
Yes.
But on 16-1, you should be ready.
My lord.
This tamasha cannot go on like this.
No, my lord. Your lordship, it's a educational institution, I know.
Students.
Yes, I know, my lord.
We as a primary school students is to enjoy when the teacher does not come. Parents is to suffer.
Yes.
Now we understand what is the importance
of the primary school.
Therefore, in yesterday's judgment, I have highlighted
Yes. I have gone through.
3 days ago,
last
3,000 teachers have been appointed.
In the?
The chief minister.
Yeah, I saw that also. That's appreciable.
Yes.
That your
3,000
is
teachers
taking
in
good
the
steps.
10 plus 2, 11 and 12 classes.
12 classes.
PGT. Postgraduate teachers.
But juvenile schools are very, very much short.
No. In juvenile schools, we have no vacancy of base level. Only promotional vacancies are there. Some cases are going on.
Yes.
I have advised them, subject to result of the litigation, you go on.
Number 2, factories can be run with ad hoc employment.
But not with this.
Not educational institution.
No.
There should be full-fledged workforce.
My lord. Different schemes are floating.
last item also may try to take instruction of the last item also.
Already approved, and the follow-up action is being taken up by the regional office Bhubaneswar to communicate with the school so that the student gets the benefit.
Serial number? 50. 50. We'll record his submission and you'll file a memo.
Yes,
the same thing which you are saying.
I'll file it.
Petition has become infectious.
No, not yet infectious.
Why?
Because he has not yet communicated anything to me.
No, he will do that.
Yes.
He will do that now. When the Patnaik says, you have to believe it.
Yes, ma'am.
He will not say without consulting his brains. Learned, the petition prayer reads, petition prayer reads as a learned senior panel counsel appearing for movies 1 and 2.
1 and 2.
1 and 2. Submits that matter may be disposed of. Since already the relief sought for by the petitioner is substantially being granted, being granted on a war footing. By instructing OP number 3.
2 and 3 now.
2 and 3, only 3.
2.
Because 2 happens to be the
board chairman
of the board. So your lordship may say 3 because 1 and 2 work together.
Appropriate instructions to OP number 3 in that.
Well, it is school.
This will be done well.
Pardon?
This will be done well.
No, I have the instruction that they have already.
He has also filed a memo to this effect, which reads as a first ordered accordingly and disposed of. Okay.
Item 31.
Given paper. Yes.
Item 31.
Yes, ma'am. In this case, petitioner was appointed as assistant teacher, my lord. Due to the, my lord, fraud committed by authority concerned, my lord, I was terminated along with other teachers also. Thereafter, I was allowed to also to rejoin, my lord. My lord, since 2011. My lord, due to the rejoin, my lord, there the
will file counter.
Already, sir, 6. Read order dated 26/9/2025.
Yes. After vacation.
This was on 26/9.
Yes.
Now we have crossed 26/11. Nothing has happened. Nothing happens. Everything will happen if I direct arrest and detention. That is the only mantra now in your state. People are not sensible. People in power are not sensible.
5 days we given. 5 working days we given.
Even Miller, they are not releasing.
He's saying that
releasing like
some days.
My salary not released.
April 4 weeks.
Sorry.
Next.
Next. They are not releasing my salary since April. Sorry.
Item 32.
You should know advocacy. So go to some school for advocacy.
So
no school in advocacy for this court-wide order dated 26/9/2025 had written with then dipped in acid as under. First now. Still the officials have not woken up. First now. When this court wanted to take some action in the nature of arrest and detention, learned AGA assures that he would confer with his clients and come back if a short accommodation is granted. First up. Ordinarily, this AGA has kept his words. First up. Next paragraph. In view of that, call this matter on 8/12. 9/12. 9/12. Next.
Item 32.
That order I can.
Carbon copy of the order to be made available to Mr. AGA. The registry will send a copy of this order to the OPs by speed post also before sunset of the day. Next.
Item 32.
It's a dispose of a case. Inadvertently, on my part, OP 102, instead of higher education, I have mentioned school on my.
The OP number 1 only. The correction.
OP number 1.
In
your case, only OP number 1.
102. Only higher word will be.
Counsel for the petitioner points out some mistake that crept in the order dated 11/11/2025, wherein OP numbers 1 and 2 are wrongly described. First, he requests the court to rectify the same and has given the format of rectification. First, next one. Learned counsel, learned AGA, one sentence you can answer. Learned AGA fairly agrees with the proposal. Next one. In view of the above, registry to effect rectification in terms of the format and issue a free copy of the rectified judgment copy if applied for. Yes.
Item 33.
Well, despite your lordship's order dated 11/11/2025, well, the opposite party number 4 is not permitting me to continue in my previous place.
OP number 4?
Yes.
Who is he?
Block Education Officer, Kendrapad. Your lordship may kindly see the order dated 11/11/2025. I have only 1 year and 9 months to go for my retirement.
Transfer order was under challenge. As they are saying that is the fag end of the career.
Your lordship has taken note of it.
Because it is within the period of 2 years.
Less than 2 years. Less than 2 years.
Less than 2 years.
Yeah.
So 7/2/2025 is the order under Annexure 3, Malad. It is at page 22.
My question is, there is interim order. It may be a wrong order. Court has got power to do right or wrong order. Till order is vacated or modified, that needs to be obeyed. Ask your PEO to be personally present before the court.
7/2/2025, the order was passed.
Correct. No, 11/11/2025.
The order of transfer.
11/11/2025.
Correct.
And the order so passed, my lord, by this honorable court on 11/11.
All right, then
November.
at least we should make an application seeking he has already left and joined elsewhere.
No, I have challenged the rejection order.
There is an order. The officials, the executive should obey the order.
Yeah, obviously.
You ask him to obey this order. This court-wide order dated 11/11/2025 had said as under. First off, order is crystal clear. It does not give scope for any interpretation. First off, its variation is not sought for. First off, next paragraph. Counsel for the petitioner complains violation of non-compliance of this order at the hands of OP number
4, Block Education Officer, Kendrapada.
BEO.
Kendrapada.
First off, this is, if the complaint is true, it should result into some punitive action, which may include arrest and detention of the officer concerned. In addition to levying heavy costs and spoiling the service records. First off. Next paragraph. Therefore, OP number 4 is directed to show cause as to why the above order is not complied with. On the next date of hearing, being personally present before the court, failing which he runs the risk of being brought before the court by police force. First off, next paragraph. However, if in the meanwhile the order is complied with, all that has been observed herein above would pale into insignificance. Share carbon copy. Next.
Item 34.
Till order is made, you are entitled to argue everything. Once order is made,
we have to
only one thing to do, comply with the order. It only reminds me of what a story which Cicero had said in Cicero's Marcus Tullius Cicero. Very beautiful stories are given. Why orders of the court should be obeyed. One instance he gives where the king ordered the execution of X on the ground that X had killed Y. When X was, Y was, the executioner was about to put X to death, Y came on a horseback.
Why?
So this executioner took both X and Y back to the king and said, "Oh king, what mistake you would have done had I executed your order?" Y came from that side, he is not fit. Then king ordered the execution of the executioner because he disobeyed the order, and execution of X because Y because he was responsible for the execution of innocent X, and X because of the presumed death of Y. So simple. Therefore, always in English law, in Roman law, in Greek law, let heavens fall down, obey the court order, obey the law. That's very important. Rule of law, rule of law is that one only. Professor A.V. Dicey.
Discipline.
Yes, follow the law. That's very important. And you have also seen what Churchill wrote a letter to Mahatma Gandhi. Mr. Gandhi, you are telling people, you are teaching people to disobey law. Tomorrow after we leave, how are you going to govern the country? Very important. Yes.
May I please?
Item 34.
My lord, no counter has been filed, but here, my lord, the prayer is that the petitioners organization has engaged some persons, which has also been recognized by the educational authorities, but I have sought for their engagement under the scheme. Now, my lord, arbitrarily the scheme is no longer there. So, under such circumstances, may I pray that I may be allowed to approach the collector, because he is the authority who can cause an inquiry and take a decision, because we are continuing since 1995. That's true. But the scheme under which the appointment has been sought for, those schemes are no longer there.
So if some new scheme comes, you can be accommodated. Anyway, you make a representation to the collector.
Approach the authority because it is of 2013. In the meantime, that has been wound up.
Petition
OP number
prayer,
3.
reads as under. First one. Counsel for the petitioner very fairly submits that petition be disposed of by reserving liberty to his client to make an appropriate representation to the jurisdictional OP number?
3, madam.
OP number
3.
By providing all necessary data and evidentiary material. First off, he also pressed that if such a representation is made, the OP number 3 has to take a decision on that within a reasonable time and in accordance with law. First off, with this proposal, learned EGA is next in the most circumstance petition is accordingly disposed of. Next.
Item 35.
Lord, I beg pardon.
Yes.
In item 33, interim order to continue.
Yes.
Not the times fixed.
If such an application is the same shall be heard and decided after giving an opportunity of hearing to all the stakeholders within an outer limit of 3 months. All contentions kept open.
Item 35.
Relating to RSCP, my lord, my.
Sir, my counter is ready, my lord, draft counter, we have got it.
The 3rd week of January we have that. There is 23 matter. The 2nd week of January.
Yes.
Let's challenge the order passed by the MSCFC, that is under the MSMED Act, basically on 3 grounds. First of all, that the bench are the members who have had the matter, and the members who have passed the order, there are different members have passed the order. Some of the members have passed final order, who are not the members of the board who have had the matter. The second is that work is assigned to a joint venture company, and only one company has filed a claim, which is not maintainable. Because
even when Bar Association argues, the other members disturb you. Anyway.
I'm sorry. Yeah. Well, because it is joint family, the joint venture, and it is a one legal entity now for the purpose of the contract. That is the reason that the one claimant cannot independently cannot claim. That is the third point is that one of the
first point is
that the members who have heard the matter,
they are not.
Some of them are not the part of the final order. Some other members have included in the final hearing.
So they are
ballot. Yes.
Are you ready in the matter?
Yes.
Yes. Is it true? First contention is true.
My first point before my learning senior argues, my first point is writ application is not maintainable. Because
I will also submit
section 18(3) of the MSME Act says that the award passed by the MSME Council is construed as an award under the Arbitration Conciliation Act 1996. So 34 is the proper remedy to file appeal to set aside the award. So read the application, various judgments are there.
Jharkhand Urja judgment, my lord, will answer this. Jharkhand Urja case, have
Supreme Court decision is not that not maintainable at any stage of imagination.
No, but award to be passed by the tribunal.
MSME Council.
Correct. Council is the statutory tribunal.
Yes.
Council comprises of XYZ members. But award is passed by alpha, beta, gamma members.
All these points can be raised under section 34 appeal division 34 appeal.
They can raise you. Any adverse order is passed against you.
Yes.
Then you
Our has already been passed. My lord, will also kindly see it is covered. Sorry, my lord. Extremely sorry.
If all contentions can be taken up before the section 34
of the Arbitration Conciliation Act.
1996 Act, then I will give you time. I will also tell that this will not be enforced against you till your application for interim relief is considered by the 34th court.
Appellate court.
34th court.
My lord, will also kindly see
It is not appeal.
No, that's
Yes,
not
yes, appeal.
It's not an appeal. Setting aside. It is not an appeal. My lord, will also kindly see.
Original matter.
The 34th language is like this, my lord.
34th, I am prepared on the question of maintainability and I will the question of maintainability. Absolutely, the Urja case is clearly will stare at his face. Good.
No, let him place. I will place my judgment.
Yes.
I will place my judgment.
Kindly read section 34.
Yes. 34 says, Arbitration Conciliation Act, application for setting aside arbitral award, recourse to a court against an arbitral award may be made only by an application for setting aside such award in accordance with subsection 2 of subsection 3.
So it is not an appeal.
Yes, ma'am. 34 is the provision to set aside the arbitral award. So 18.3 says it constitutes by any award passed by the MSAB Council
to be an award under 96 Act.
Yes.
My lord, will also kindly see. 34 scope is very, very limited. Not only that, if the judgment order is a nullity and without jurisdiction, writ petition is maintainable, and that has been that objection and that is the answer. Please have patience. Please have patience. So, my lord, that's judgment. I am planning out the note, my lord. That's what kindly see. The note I have appellation of judgment. My lord, may kindly see this. Yeah. Good. Look at the page code. My lord, let's kindly see page 22. All the judgments which my lord friend referring is all on merit. They have decided on merit only. So merit naturally section 31. Let's kindly see the
page number.
Page 22. Relevant para 11. Para 11, madam. Even it is entered after completion of 120 days. From a reading of section 18(2) may placement.
83 of MSAB.
It is of the MSAB Act. It is clear that the council is obliged to conduct conciliation for which provisions of section 65 to 81 of the Arbitration and Conciliation Act 1996 would apply as if the conciliation was initiated under Part 3 of the said Act under section 18(3). When the conciliation fails and stands terminated, the dispute between the parties can be resolved by arbitration. The council is empowered either to take up the arbitration on its own or to refer the arbitration proceeding or to an institution or as specified in the said section. It is open to the council to arbitrate and pass an award after following the procedure under the relevant provisions of the Arbitration Conciliation Act 1996, particularly section 20, 23, 24 and 25. There is a fundamental difference between the conciliation and arbitration. In conciliation, the conciliator assists the parties to arrive at an amicable settlement in an impartial and independent manner. In arbitration, the arbitral tribunal arbitrator adjudicates the disputes between the parties. The claim has to be proved before the arbitrator, if necessary, by adducing evidence, even though the rules of Civil Procedure Code or the Indian Evidence Act may not apply unless the authorities agreed. Oral hearings are to be held. If the appellant had not submitted his reply at the conciliation stage and failed to appear, facilitation council could at best have recorded the failure of the conciliation and proceeded to initiate the arbitration proceeding in accordance with the relevant provisions of the Arbitration Conciliation Act 1996 to adjudicate the then para 14 million, para 15 million. The order dated 6/8
Is a nullity.
is a nullity and runs contrary not only to the provisions of MSME Act but also contrary to the various mandatory provisions of Arbitration Conciliation Act 1996. The order dated 6/8 is patently illegal. There is no arbitral award in the eye of law. It is true that the order under the scheme, the Arbitration Conciliation Act 1996 and arbitral award can only be questioned by application of Section 34 of the Arbitration Conciliation Act 1996. At the same time,
it cannot
when
be
an order passed without recourse to arbitration and is uttered disregard to the provisions of the Arbitration and Conciliation Act, the Section 34 will not apply. We cannot reject the appeal only on the ground that appellant had not availed the remedy under Section 34 of the Arbitration Conciliation Act 1996. The submission of the senior counsel appearing for the third respondent that there was delay and laches in filing writ petition cannot be accepted after 6.
So what you say is, writ petition is maintainable because it is not an award at all. To challenge, invoke Section 34, there has to be award first.
Right.
In the absence of award, Section 34 is not invocable. Only way is to come for 226.
I'm obliged, Miller. No,
227.
Yes, I'm obliged because it's without jurisdiction.
Yes. That will also kind of.
The judgment also have filed to reference to India Glycol.
Just Indian Glycol.
Indian Glycol I have also filed because I knew that they will supply.
Page number?
Page number.
Page first. Page 5.
No. That the ruling that they have wrongly cited without giving the name of the parties, they have given the citation. That is next to me.
Page 203. Page 203, my lord. Page 203. The same judgment, no, just one.
Definitely it was.
It's 203. My lord,
Let me place my judgment. I have marked it properly. That's why page 5. Your Lordship kindly have a glass to page 5.
India Glaciers.
Yes. In terms of Section 19, an application. Paragraph 10. In terms of Section 19, page 5, paragraph 10.
1 second. What happened to whether this matter was taken to Supreme Court?
Yes. This is the Supreme Court judgment. That judgment I had cited was the Supreme Court judgment.
Supreme Court
judgment. The judgment is Supreme Court judgment. That is the Supreme Court judgment.
You are right.
In terms of Section 19, an application for setting aside an award of the Facilitation Council cannot be entertained by any court unless the appellant has deposited 75% of the amount in terms of the award. In view of the provision of Section 18(4), where the Facilitation Council proceeds to arbitrate upon a dispute, the provision of the Act 1996 are to be applied to the dispute as if it is a pursuance of an arbitration agreement under the subsection 1 of Section 7 of that Act. Hence, remedy which is provided under Section 34 of the Act 1996 would govern an award of the Facilitation Council. However, this is a superadded condition which is imposed by Section 19 of MSME Act 2006 to the effect that an application for setting aside an award can be entertained only upon the appellant depositing with the council 75% of the amount in terms of the award. Section 19.
Where is the nullity? Where is the nullity aspect?
Not maintainable. Writ petition is not maintainable. That is the verdict of the Supreme Court.
1 second. Not maintainable if there is an award.
Yes.
If it is a case of nullity,
yes,
no award. That is what is treated in the decision which Mr. Mishra has banked upon. Where is the word nullity? Both are Supreme Court judgments only. Now I have to apply which of the two judgments govern the nearest version of the case.
There was an award.
No, I will not agree with that. Where tribunal comprises of A, B, C,
yes,
an order by A and B is a nullity. An order by B and C is nullity. An order by other than A, B, C is a nullity. That's the law. that is referred by the Supreme Court in 1987, Sampath Kumar.
This can be raised under
that is
section
not.
34.
If there is an award,
Order passed by the Facilitation Council is a nullity.
if that is the contention.
So read code, where is this read code jurisdiction?
Read section that 23 judgment. That answers your question.
Which I have to send a copy also to my lord.
Come to the paragraph number 50. It's 50. The settled position of law of precedent, which precedent in English law by Rupert Cross says, where two decisions of the same court are cited, the one which matches the facts of the case to a greater extent, that should be followed. Both are Supreme Court judgment now. As between them, latest should be followed.
Yes.
Suppose if they are rendered the same date, then the question is, the one which adopts to the maximum amount of factual position should be followed. That is the law. There are Supreme Court judgments, which Professor Lakshmi Kanta in his Precedent in Indian Law has discussed.
If award is a nullity.
Yes, its award is a nullity is nothing.
No. They can raise this point.
That point is not answered. I don't agree.
Under section 34?
No.
Because extraordinary jurisdiction under Article 227 or 226 or 227.
That is answered to the Supreme Court. Kindly come to page 15 of his judgment. Kindly read section 15.
Order dated 15. Para 15. The order, para 15, the order dated 6/8/2012 is a nullity and runs contrary not only to the provision of MSME Act, but contrary to various mandatory provisions of Arbitration and Conciliation Act 1996. The order dated so and so is patently illegal. There is no arbitral award in the
eye of law.
It is true that order under the scheme of the Arbitration and Conciliation Act 1996, an arbitral award can only be questioned by way of application under section 34 of the Arbitration Conciliation Act 1996. At the same time, when an order is passed without recourse to the arbitration and in utter disregard to the provision of Arbitration Conciliation Act 1996, section 34 of the will not apply. We can't reject this appeal only on the ground that appellant has not availed the remedy under section 34 of the Arbitration Conciliation Act 1996. The submission of the Lawrence Senior Counsel appearing for the third respondent that there was a delay and lapses in filing writ petition also cannot be accepted
because against nullity, no limitation.
After 6/8 order.
So your contention, except naming you here, your contention is considered by the apex court. They have not mentioned your name here because other counsel argued.
No, yes, case, my Lawrence Senior argued in my favor. The contention I have raised, totally that decision. That decision and the contention was recorded.
That judgment also have filed. That judgment also have filed.
That decision I have got.
I have also filed it.
No, where is the word nullity in your judgment?
That case was decided on the merit. They are challenging.
I relied upon the decision where it says that writ petition under Article 226 or 227 is not maintainable because there is an alternative remedy.
There is an award in the eye of law.
Yes.
Here in the eye of law, there is no award.
Rightly or wrongly.
My lordship, page 85 will also kindly see.
85 for what? For what purpose?
Only for the purpose that the members who have had the case had not the party to the order. And some other members, some of the members had.
Some members heard and some members decided. Page number?
Page number 85.
85 of your petition.
My lord, Annexure 5.
Go to 85.
May I please pull it?
All these petitions are like that only.
No, two petitions are like that. For the petition, other points are also there. Same on the constitutionality.
In other
nullity
also
is
same ground
no,
is there.
this ground is not there, but other grounds of nullity is there.
Other grounds of
Nullity is there. They're without jurisdiction. They didn't have the act has absolutely no application to the case. That is applicable in all the 7 cases.
These 2 cases I will decide now. Then rest of the matters you will hear it later because that they require a deeper examination. In these two, there is no award and therefore we cannot. In other matters, perhaps you may have to go to 34.
No, that case also, Lordship will say that order is also null because the act has absolutely no application. If there is act has no application, the question of award, there is no award in the eye of law. Because the award is nullity, that also that case also will apply those cases also.
Why act is not applicable?
Because the act has no application because first of all, there is no conciliation failure. There is absolutely no conciliation. But as per section 18, the conciliation has to be. Please have patience. Please have patience. You can interpret. My lord,
one second.
Yeah.
In the first 2 matters, was there conciliation?
Yes.
There was conciliation. But members who heard did not pass the award.
Did pass the award.
Therefore, award is illegal. Understood.
This is one.
In the second batch of petitions, the other cases, was there conciliation?
No.
There was no conciliation.
Conciliation was there, but they did not proceed in accordance with after the conciliation failure. They did not go for the arbitration.
They did not go for arbitration.
They did not go for the arbitration as required under section 18.2. Please have patience. I request you to not to interfere in my
18.2.
So 18.2 they did not
read.
18.2 years for jealousy. And not only that, the Act has absolutely no application because Act is regarding to manufacture and services. This is a vast contract. And clear judgments are there that these are all vast contract matters are not applicable to the MSMED Act only. The Act has no jurisdiction, the authority has no jurisdiction to entertain the application also. That is applicable in all 7 cases. Let's look at section 18.2.
No, whether it is a works contract or some other.
Record itself. The record itself. Not that there is no dispute about that.
No,
that on the record itself.
That factual dispute, I cannot actually.
No, factual dispute at all. Had there been a factual dispute, that would have been different. But there is no factual dispute at all. 18.2 also actually, please have patience. Let me complete me.
Let me I will examine this judgment. Jharkhand decision went to Supreme Court. I will examine with regard to nullity. Your Lordship may fix another date. I will examine and all aspect.
No time will be granted. Yes, again.
Well, section 18.2 Lordship can listen.
18.2 read.
This is the act.
I can grasp if you read.
Yes, my lord. The notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, with regard to any amount due or section under section 17, make a reference to micro and small enterprise facilitation council. 2. On receipt of a reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek the assistance of any institution or center providing alternate dispute resolution services by making a reference to such an institution or center for conducting conciliation, and the provisions of section 65 to 81 of the Arbitration and Conciliation Act 1996 shall apply to such dispute as if the conciliation was initiated under part 3 of that act. 3. Where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration or refer it to any institution or center providing alternate dispute resolution services for such arbitration, and the provisions of Arbitration Conciliation 1996 shall then apply to the disputes as if the arbitration was in pursuance of an arbitration agreement referred to in subsection 1 of section 7 of that Act. So conciliation, it has the law is very clear that it has also been decided by the Hon'Ble Supreme Court that after conciliation failure, the parties are to be given, if the council itself decides for arbitration, itself goes for arbitration, or it can put any other organization for arbitration, then he has to give an opportunity of hearing, and thereafter he has to proceed with the arbitration. There we'll have the scope of maintainability, all these things will have the scope, and we'll have to, but the thing is that you also kindly see that very same judgment, my lord, Urja case, my lord, that judgment page 22, para 13 will also kindly see. Page 22.
No conciliation at all.
No, here is the conciliation, after conciliation failure, immediately pass the award without giving an opportunity to file for arbitration and all that. So
after one sentence, you have to put the full stop. Because I have to assess.
Oh, I'm sorry, I'm so sorry, my lord. I'm so sorry. My lord, the conciliation failed. After conciliation failed, he has to he has to go for arbitration. The council has to go for arbitration. Either he has to go for arbitration himself, or can send it to another body for arbitration. So if he decides, in that situation, what happens? He has to stop there, and again he has to direct the parties to file their objection and all that, because it's a money claim. After all, it's a money claim, so we have a right to object and all that, right to file a written statement, and we have a right to him be heard. Not only that, we have a right to be raise the question of maintainability and all that, those aspects. So what he has done, the day when he conciliation failed, same day, at the same time passed the award. That is the reason I have said that it is a nullity. And also, Lordship, can you see this?
Just write down your submission.
Yes,
Your Lordship, another aspect is there. Section 19, Your Lordship, kindly have a glance.
Submits the following proposition. Section 18 of the MSME Act is as clear as gadgeting water. First, it contemplates two-tier system. First, the first tier relates to conciliation of proceedings as a precondition, and if it fails, the arbitration proceedings have to be separately undertaken at its own hand or at the hands of the referee. First, in the instant case, the council immediately on failure of the conciliation has entered the award without initiating the arbitration proceedings, as apparent from the record, and therefore the award is a nullity. First. Second point. Secondly, Mr. Mishra draws attention of the court to page 85 of WP number
113403.
To demonstrate that the members who heard the matter were different from the members of the council who passed the award. And therefore, it is not the council which passed the award. First, even otherwise, in Gullapalli Nageshwar Rao versus State of Andhra Pradesh, the apex court has held that the one who hears has to decide. First, number 3. Mishra submits that section 34 contemplates there being an award in the eye of law, and in the instant case, there being none, invocation is not possible. In support of that, he cites the decision of Apex Court 2023. Sorry. Your point is over now?
No, my lord. I have got another point.
Then we will hear it.
Only on the same point, my lord. Only same point, my lord. Because that is para. Your lordship, can you look at para 22? That submission. Same Jharkhand Orissa case, my lord. Para page 22.
22. I have read full page.
Yes, your lordship. So that is exactly very same point has been also been decided. What's your lordship directed to conciliation? The lordship yes. And the other part, my lord, they are regarding that it's a contract, my lord. The contract is there on record, my lord. Is there? So it's a
also submits that the act itself is not applicable to the cases of works contract.
Works contract, right?
And that there is no dispute that there is no works contract.
The works contract is not amenable to the. That is what I have cited judgment to the repeat also. And the other point is getting joint venture, my lord. The joint venture, if it's joint venture, it is as per the law, it is a legal entity. So if you have entered into contract with joint venture, one party independently cannot make any claim. That is only in first case.
Only in first case.
Only first case.
First WP. In the case of joint venture, one party cannot invoke MSME Act at all. Yes. Yes, sir. You have answered the first question by relying upon the
conciliation
judgment.
Conciliation. Your lordships kindly have a glance to page 44
of your judgment.
Award. That is passed in, that is attached to the WPC 11343.
44.
343.
Go to 44.
Conciliation was initiated.
And the same day award is passed.
No. 3 to 4 times has been given.
No, it's in conciliation.
Conciliation, yes.
Conciliation.
Yes. Being failure in conciliation, thereafter 2 to 3 dates has been passed.
Where is the question? Is
yes. Award, your lordships kindly have a glance.
That point is not there. That point is not there in that case. This point about the fact that that point is that the only that point the member are different. That only that point is there in that case. Other point is not there in that case.
That case it is not
there. So is
in the files.
So, conciliation was made in all batch of cases.
No, that other points will not there. He says members who heard were not the members who passed the awards. The best way is, instead of my treating all the aspects and saying that there cannot be arbitration, the best way is to set aside the award, remand it to the council. Council should consider both the contentions of all the parties in the light of section 18 and your decision and his decision. Then they pass the
award. That will be the most fair decision.
No, provided he agrees. Otherwise, I will.
He is not prejudiced thereby.
I can't compel him like.
No,
I'm not compelling.
Mandate is 75% deposit, section 19. They are not depositing a single part.
They need not. They need not. They are not under 34. They are under 227.
No. Not 34. Even their prayer was in the petition to set aside the award. Your lordships kindly have a glance to section 19.
Yes.
Section 19, your lordships kindly have a glance.
What it says?
It says the application for setting aside decree, award or order, no application for setting aside any decree, award or other order made by either by the council itself or by institution of the
award
also.
Tell your council.
Well,
you have to brief your council. There is no award because of 23 Supreme Court.
Their prayer is to set aside the award.
Prayer, if they say set aside the award, it does not mean it is award.
Yes.
They have to pray that way only, because there is a perpetuate award. A perpetuate award is not an award because of 23 Supreme Court. Therefore, what I suggest is, if I consider that other contentions, then they will escape completely. Don't do it. Let them let him take to council, so that council will decide. I'm telling it in your interest. Otherwise, very happily, within 5 minutes, I will give the dictation. That will not do complete justice to you. You will go leave the court hall with heartburn. That I don't want. The best way is, several contentions you are urging before me. If I accept the first contention, the only option which I can tell him is remand, so that all contentions will be urged. Otherwise, if I set aside this and take up his contention that works contract will not fit into this act, where do you stand? Think about that. At 2 o'clock you come.
Yes.
Yeah. You just put it to a client, so that unnecessarily we go on. Injustice should not be done to the litigants. Yes.
The next item, 57, my learned friend. Here I have to sort for instruction. May I pray for 7 days time regarding payment to the petitioner?
Payment in the post of headmaster will also last of the director. Let it take 7 days.
7 days, not more than that.
On the 8th we will call this.
Yes, ma'am.
On 8th. Or next week.
Lords, Lords.
My lords, item number 50, I may be pardoned. That since he is a private student, should be the board will communicate to the student directly instead of the school. But they have agreed with they have granted the prayer.
Whatever you want to say in the this one, in terms of that, I'll structure that. All right.
I'll put it on the mail.
Yes. Anything you want to say? No. Okay. Vera?
No, man.
The opposite party filed its claim in the year 2020. After 3 years, award has been passed. Members are regulated by the state government. Their posting was regulated by the state government. So, Morning Lawrence Senior's contention that the members who have been heard the matter at the time of passing the award, they are not. So I have no role of
Correct. You have no role. We don't falter you. But the award cannot be sustained. There are English courts, which I should cite. There are students here. In a bench comprising of 2 judges, one judge was dozing. And that judgment was set aside on the ground that it did not constitute the court. Means those who hear Mullapalli Nageshwar Rao, which have been taught in the law school, the state of AP versus Mullapalli Nageshwar Rao, relating to the routes allotted under the Motor Vehicles Act to the private operators. There Mullapalli said, Apex Court said, one who hears, he should decide. Those who heard have gone, and those who have passed the award never heard. How is it sustainable? Therefore, I suggested consensual order can be made. I provided your claims permit. Otherwise, I have to treat your contentions and remanding the matter. So, keeping open all contentions to be decided by the council within a time-bound way. Otherwise, they will take another 3 years.
Yes.
In that, you will suffer.
Yes.
That appears to be sensible. I leave it to your advocacy. What do you say, Mr. Mishra?
I have no, so far as first two cases are concerned.
All cases have to be dealt with. All cases, 7 cases have to be dealt with.
First also, I also said that that is the most fair judgment.
The learned senior advocates appearing for parties vociferously having argued the matter at length, now graciously agreeable to the suggestion of this court that the impugned orders were awards, regardless of their nomenclature, be set at naught, and matter be remanded to the council for consideration afresh in a time-bound way, that is 6 months.
3 months.
No, I'll have to file objection.
There is a provision in MSME Act to dispose of within 60 days.
Yes.
In a period of 60 days.
No, yes, we'll have to file objection to that. Please don't give opportunity to file objection because I have not filed objection.
Assuming whether you want to file or not, Parliament says 60 days. Parliament says 60 days.
Yes.
Whether I right, there are two judgments of Bombay High Court. Bombay High Court interpreted it as directory, but still 60 days is given there.
Yes, I agree.
Within a period of 3 months. Within a period of 3 months.
3 months.
Within a period of 3 months. Keeping open all contention of the parties. First, ordered accordingly and read.
Ballot kindly to decide the materiality also. Otherwise, all contentions which they will not
90 days. My lords, it is
3 months.
3 months.
So,
Contentions
all contentions by rescind order.
Filing the pleadings.
Yes.
Has to be obviously given. Ordered accordingly.
Rescind order, my lord, rescind order.
They will first read that.
They will not first read that. They are executive persons. They do not normally do that.
We can't direct.
Much obliged.
First meetings. Yes, go on.
18.5 days. 90 days.
Yes, you are right.
Much obliged.
Thank you, Mr. Behra. Yeah.
Item 37 has been adjourned. Item 38.
Please, madam.
They have filed counter, my lord.
I have also filed rejoinder, my lord.
Yes.
Copy of the rejoinder not in my record.
Solved. Rejoinder copy solved, my lord.
You want to file rejoinder?
Filed, solved, copy solved, my lord.
They have filed rejoinder copy would not with me.
Give copy.
Copy. Next week, my lord. We have dismissed, my lord, sir, from public.
Let the request of learned ASC. In the meanwhile, copy of the rejoinder shall be served on him by the petitioner.
Obliged.
Item 39.
Please, your lordship. Your lordship, my senior is held up in another court. Your lordship may kindly adjourn my
Second week of January. At the request of.
short date, your lordship.
Once you are not ready, it will go. That's next.
Item 40.
May I please, madam? This is a matter, my lord, where the petitioner is a retired assistant professor, my lord. My lord, he has not sanctioned with the final pension, my lord, on the ground that the vigilance case is pending, my lord. My case is, my lord, the vigilance case has ended with the final form. And my lord, the vigilance authority has already exonerated it, and they have also filed the affidavit that stating that the charge has the petitioner has already been absolved. My lord.
Yes, Mr. Behra.
This last report.
Yes.
They appear for the Department of Vigilance.
Vigilance. You said other day.
Yeah.
You need not repeat. I remember.
No. That's another case. I appeared in another case. But in this case, now we have filed a counter affidavit in saying paragraph 4, saying that in fact a vigilance case was initiated against the.
What happened to that? You tell me.
That ended with
in his favor.
No.
And then it's he is absolved.
Final form was filed in the month of April.
Tell the date.
To 30th for 34/2023. Final form number 15 dated 30/4/2023. Submitted before the Lord Special Judge Business Chapter.
That is, no case is made out against you. So it was a criminal case. Vigilance case is criminal case in your state.
Petitioner
Under
along
which
with,
section?
petitioner was the ex
Under section 13(2), 13(1)(d).
That
Prevention.
1988.
13(2), 13(1)(d) of the Prevention Corruption Act. Read with 468, 471 and 120B of IPC. Lordship can look
My lords,
paragraph 4,
13(2),
13(2) within bracket 2, 13(1) within bracket, 13 small d within bracket of the Prevention Corruption Act 1980, and under section 468, 471
and IPC provisions.
Yes, 120B in works, because apart from petitioner was
there were other
already sent to other persons who were
common object.
correct.
149. Yes.
My lords, since he is entitled to, I'll take instruction.
What instruction will do?
My lords,
On what ground you have withheld?
my lords, he is getting.
Your lordship may see the.
You getting the provisional pension?
Provisional pension, my lord, nominal, my lord, 8,000.
Let him take a card.
My lord, your lordship may see the rejection order. Rejection order.
Second week of January 20.
My lord, your lordship may saw that, my lord.
Next.
Your lordship may 1,000.
Secure lordship, 39, I just got delayed 30 seconds in reaching.
No, we can't do anything. Next.
Next month.
Second week of January 2026. Yes. Next.
41, my lords. The CDA has filed its counter. They haven't served a copy, my lords.
Give a copy. Give one more copy.
Because the CDA is the main answering party, my lords.
Yes.
The allegations are that, in fact, he was the builder, the landowner. Now he makes allegations against the building.
Yes.
Anyway, my lords.
You copy.
My lord, the CD has given a counter, which is a faulty counter, and they have not mentioned that no copy of BP, building plan number 136/2005 has mentioned. They have only oral written, they have mentioned. There is no substantial proof, no file number, no note sheet, no approval memo, no forwarding, no inspection record, no fee receipt, nothing, no signature verification. And as per the RTI, so we searched the RTI from CDA, they have already informed us that the 136/2005 BP number is not traceable.
Not care anybody. You will not care anybody. You will not care anybody. You have to look at the judge. You have to take the judge on the garden side. Is it not? That you are not doing.
Sir.
Only, sir, Learned Senior Advocate is saying, copy of the counter is not filed on. File a copy. You are the petitioner.
I'm the petitioner.
Petitioner to serve copy of this.
No, the CDA has to give.
CDA has to give. I'm not supposed to give. CDA has to give.
My lord, I am first.
He will not give. Who has CD?
My lord.
You have copy of this one. He will give it. Yes, say oral assurance.
And so one more, sir. My lord.
Third week of January 2026. Yes.
As per the previous order, already CMC was supposed to be received the copy, and they have received. They either don't know whether they have appealed or not.
Item 42.
May I please your lordship, this is a rehabilitation assistant contractual amendment for regulation matter. Your lordship has passed similar cases, Lord. This is wrong.
You are not given to him.
And I have given it. He has gone to the, I have given.
You have changed the factor.
I have changed, I have mentioned the read application corrected also there.
You have right.
My lord.
Just looking.
I have seen my lords.
Same.
My lord, I may be allowed to appear. I am appearing for the OP number 4, my lord.
OP number 4. Yes, matter is covered. It's nothing there is.
Obliged, my lord. My appearance may be indicated.
Kindly tell your name, sir.
Diptendu Sundar Rai.
Yes, for OP number?
4, my lord. The headmaster of the school.
Item 43.
May I please?
Yes.
In this case, the petitioner filed this writ application to correct the father's name in his clause 2 council certificate, my lord.
Clause 2, clause 12.
My lord. Clause
10
2.
plus,
My lord.
10 plus 2.
My lord.
Your name of the father to be changed.
My lord.
Who appears?
My lords, I appeal for
Tell the father's name.
No, that is my case is the application sent for correction was technically having some fault. So that has been communicated to the school. The school is actually to send the document corrected.
Who appears for the school? Who appears for the school? School is served.
OP number 3.
OP number 3 is served.
My lord.
You take police notice to OP number 3. Things will happen immediately. Issue emergent police notice to OP number 3. Not represented? No. OP number 3
Not happening.
who has remained unrepresented despite service of notice. Since certain work has to be arguably accomplished at its hands. First off, most immediately after service. Next.
My lord, I am the petitioner of this writ petition. My lord, the previously the opposite pad number 3 and 4 has not issued properly because the office order may reflected as the address cannot be located. The new address have been mentioned in this memo and may be kindly directed to resend the copy of the petitions again in the new address.
The new address will send.
And my lord, I petition has been
Terms of order dated. Put in earlier order. In terms of earlier order dated 31/7/20, in response to order dated 31/7/2025, petitioner has filed a memo as under. First up, registry to act upon the same. Yes, if all compliances are done. Yes, next.
Item 45.
Which reads as well.
45, Your Lordship, I beg your pardon, Your Lordship. May kindly pass over, Your Lordship, on.
No, pass over, brother.
Your Lordship, my senior.
At 3, reference we have.
Last item taken as last item. Taken as a last item, Your Lordship.
In the call next week.
Can I suggest, my lord? Can I suggest subject to my learned friend?
Yes.
Accepts it. He seeks a time-bound disposal of the application pending before the MSME Council. Keeping the issue of maintainability open, dispose of the
over. He has argued your case.
That is what his prayer is. Last day he also prayed. Keeping the maintainability issue open, we'll raise it there.
Petition prayer reads as done. Learned Senior Advocate Mr. Rath appearing for OP numbers.
OP number 3.
OP number 3. You are the contesting party.
Yes, sir.
Who happens to be the contesting party? You suggest that a direction be issued to dispose of the pending application in
before the MSME Council.
Pending on the file of MSME Council in a time-bound way, keeping open all contentions, including as to maintainability.
Yes.
First, with this proposed counsel for the petitioner is agreeable. Next one, in the above circumstances, petition is disposed of. The task to be accomplished within a period of 90 days as prescribed under section 18.5 of MSME Act 2006. Yes.
In the second matter, my lord, senior also appear.
Same thing.
Same order.
Same order.
Same order.
Let me just name that council. The council is Micro and Small Enterprises Facilitation Council, Odisha, Kata. That's the council. Page 17.
Page 17. Yes.
I think that was his prayer last date.
That's what.
Very grateful.
Item 46.
Notice
46, my lord.
Yes.
46, I'm appearing for the opposite party, my lord. The ratio has already been decided by this Hon'Ble Court. Lordship kindly remember in the State Council for Technical Education, from the date of judgment, in fact, the journey was up to Supreme Court. The after judgment of the Hon'Ble Apex Court, they regularized the service. Then a lordship said that no, from the date of the judgment of the writ application. So in two cases, a lordship has already been decided this matter. So this is one of the cases. So my case is covering that case. Pious order and also
I'm in this case I'm appearing for the petitioner lordship. Then submit appeal go through lordship can you call it 100.
Judgment why you are going to
covered.
Is it covered? Lordship see that.
You were there, you won't time.
I just came.
You should be fair to the court.
Yes.
The tendency of the cases is increasing because of unnecessarily taking the time.
I have not gone to that.
Yeah, just look into it. It's the decision on the party. Just 4 pages.
Yes, sir.
Just give copy to it.
You will get everything. That is in the also in the file I found that matter was already settled.
Give our copy. Just look into it. Yes, sir. You should be in a position to say within 30 seconds. What is this? Otherwise, all cases are pending like this only. Arguing.
In fact, we regularized in 2024. And the judgment is 23. It okay. It don't say that. Last term it comes. From the date of the judgment of the writ petition, okay? The said order should be construed as read as being effective from the date of the writ petition was decided on such and such.
Yes, but in my case, my prayer was from the date on which I have completed 6 years of continuous service.
That cannot be done.
That cannot.
Because of this judgment.
Yes, sir.
I cannot take different lines depending upon which advocate appears before me. One consistent stand of the court.
That's correct.
In my case, Lord, so decided to.
I will take observation. We will file. Don't worry. We'll say that. But
you want time in that?
Yes.
Let it come to
yes, sir.
Next week.
Yes, sir.
Okay.
Grateful.
Call the week of Yes.
Item 47.
He has to answer his client.
Yes. Grateful.
47 minutes regulation service continuing since 2008. Covered by your lordship's judgment. Lordship kindly say Annex 10.
No, when you say covered, he should agree.
No, the last time
otherwise I have to argue that you are
all right.
matter that he is not now.
All right. Lordship. Last time lordship directed to say whether it is covered or not.
Mr. Behura, just have you looked into it.
My lords, I have sought instruction, my lords. I will take instruction.
Call the next week.
Next week.
Next week.
Next week, my lords, make that later.
At the request of Mr. Behera. Next.
Item 48.
My prayer is to direct the appeal number 3 to comply the order of the order dated 31
OA number 2340.
That your lordship has directed me to serve a copy on this government.
What is that OP order by OAT?
48.
2340. Under Annex 3, my lord.
What is the, which is the relevant page? Order, operative portion.
My lords, you have received instruction.
Why have you not completed? 6 months was given in 2011.
My lords, we received on.
No, what do they say? Why they have not completed?
11, my lords. I'll file counter. Your lordship grant 1 week, 10 will file counter.
My lord, the orders.
One week for filing the counter. Finally, this case appears to be one where heavy costs need to be levied if petitioner succeeds. Of course, the version of the OPs also I have to look into. All right. In this, I will impose a heavy cost to the 31/1/2011 See the kind of harassment which the citizen suffers at the hands of the government. Yes.
Item 49.
Yes, sir.
Let's say in the last date of hearing, my lord, on 27th of October, my lord, opposite party no 9 has taken time to file counter, my lord, reply.
I have already filed yesterday. You counter copy I am something, my lord.
You have to come from outstation.
My lord, I am from Chhattisgarh, my lord.
So take some date in January.
January, my lord.
Which date will be convenient, please, sir?
19th January.
19th January. 19 we have posted a bunch of matters. Can you choose another date?
27. 27.
27 January. 1 second. 27.
Let's see.
27.
My lord. Let's see, state has not filed the opposite party number.
My lord, it is ready.
6 to 8.
The instruction is that
In the meanwhile, counter may be filed by those who desire to file one.
My lord.
Yes. Otherwise, petition averments will be taken with face value.
My lord. Let's say I may be continued.
In order to continue. Yeah.
Item 50 has been adjourned. Item 51.
Yes, sir.
Well, yes, my lord, my data is go you.
2 weeks time may be granted to file counter, my lord.
2 weeks for filing counter finals, filing which petition averments will be taken at face value. Call after 3 weeks. Yes.
Item 52 has been disposed of. Item 53.
Yes. Bye.
There are a bunch of cases. I am in the few. The first one is, but there is an order in the first case to the state government to cause an inquiry and submit a report to this Hon'Ble Court. All these petitioners in opposite parties were directed to appear before the authority concerned. And he has also called us, and we have appeared there in 2 to 3 occasions, but no report has come yet. The case is
inquiry about what?
Yes, this actually the allegation of fraud is there, madam. The entire government, because there is a procedure under the statute how to release gratuity in favor of an employee of an aided institution.
Who are you?
I am the person. My claim is I am the genuine employee, duly appointed by the governing body of the institution. But the person, those who have been fraudulent appointment, I have given 5 examples. In all these cases, everybody. First, somebody has not the required number of percentages to be appointed as a lecturer, but the relevant time it was 54%. Somebody having 49%, he has been appointed and got granted from the government.
But subsequently, that was the...
No, that is not coming in this way. That the appointment is prior to that. That Melody is referring to that other case we are arguing. That 48%. That is only from 91 to 97. This was the period. Prior to that, it is 54%. And these appointments were of 80s. So this has nothing to do. That rule, Melody...
They do not have that...
no, that is one.
Nobody has 54%.
No, but I'm just giving you examples. Yes, ma'am.
How many have requisite percentage?
But first of all, at least one, the principal who has been appointed and approved, he didn't have that qualification. 49% something. And he has tried also by repeating the second examination, he could not qualify.
You staked your claim for that post?
Yes. These are the interest liability. This has been come from the tribunal also. Some of them come from the tribunal. So Now, another person, those who has appointed a teacher in another institution, he has also gotten approved. All the documents were there before the court. That is why the inquiry, re-inquiry was directed.
What the inquiry said?
The inquiry report is yet to come. That is the report also in the noting in the,
for the OPs.
by state government.
May I submit, madam?
Yes.
This is that matter. Your Lordship has dealt with in the batch of review petitions. Lordship may see.
Review my with at the outset, review has nothing
Will
to
not
do
allow
with these
you.
cases.
Kindly see, your Lordship.
Here.
1 second.
Let us go case by case. I am satisfied. What is the issue in this?
This will not allow me. This is a case of a peon.
Which one?
Clerk, I'm sorry. This is a case of a clerk. And he is arguing about a principal.
No. I am saying well at the outset. Yes, sir. Let me start with each of the cases. We are the petitioners. The petitioners.
I am here, you are.
Yes.
Well, I am the petitioners, man. That is why because my lord put me a question, what is the inquiry and all this, why this direction, and that was I have clarified.
The court has no power to ask some.
My lord, definitely, who says no?
Yes,
because
there are 4 inquiries taken up by virtue of orders passed by this honorable court. Division bench of this honorable court has upheld to the inquiries. Pursuant to the inquiries, grantees have been released in favor of some of the employees of the. Here is a case, my lord. Your Lordship will find I have given a compilation of document. I'll show your Lordship. All those inquiries are upheld. In a one particular FAO concerning one employee, he is trying to reopen the issue like a PIL and now raising issues before your Lordship beyond the purview of order passed by the Education Tribunal. Lordship may kindly turn to the compilation of flag inquiry.
Before that, you are present before the tribunal.
Yes.
Shall I draw my lord's attention to the first? Let us be clarified with the facts. What I am stating, my lord, I am going by the records. Kindly see, my lord, order dated 7/3/25. 7/3/25 passed in a batch of cases, my lord.
In FAO,
the first is 737.
637.
637. Order dated 7/3/25.
7/3/25. Go to order dated 7/3/25.
Shall I read, my lord? I have copy.
You have copy?
Yes, my lord.
Use that copy.
This is the order that the report was directed by a coordinate bench. It has not come. But I can argue also if my lord.
That's not required at all. I have filed IS.
They are saying because
This is prayer before the FAO, I mean Education Tribunal. How can he expand that to the whole employees of the college? Kindly see the prayer before the tribunal.
My lord, I pause that. Comment on that.
Take the money for a front-end manner.
Lordship has asked that question. What was his prayer before the tribunal? I have filed one IA also. Now there are 4 inquiries. Lord, I'll demonstrate.
I will come to all these.
No, on 7/3/2020.
Lord, that is right.
Yes.
But I have filed
for
order.
But right. Lord, I thereafter have filed one IA. Your Lordship has already heard. If I remember, no. If I remember, the day one, I have filed one IA. Lord, all these facts are not brought to the honorable court's notice. Lord, kindly take up my compilation. Your Lordship will feel that inquiry is absolutely not required at all. Kindly take up my compilation.
This order.
No, not recalling. Kindly take up 1 second, Lord. It's not one
case merit. This is
yes,
I am ready on the merit of the case.
I kindly take up my compilation, Lord. Kindly take up my 1 second.
This order has to be
1 second. 1 second.
Mr. Rath and Dash, we will take up this matter in the new year.
Well, I'm so sorry. I'm so sorry.
Because they are anxiety.
Even otherwise also, because we have reference. Today we have reference at my lord.
I know. But I'll humbly pray, my lord. This is the way they are trying to avoid the.
I am ready today. We are
taken place.
We are suffering.
2012 matter, my lord. And today some of them are retired, some of them are.
We'll have it on Tuesday.
Tuesday 2 p.m., my lord.
Tuesday 2 p.m.
That's right.
This too. My lord, second, two, second.
I'm interested in hearing of this matter.
Yeah,
that's what.
Yes. But this order, it is no. My duty is to bring these facts to the notice of this honorable.
Yeah, you are operating for inquiry.
Not operating. There are 5
Mr. Rath has come for this case only. I am doing this case from the beginning. Without running the case, I can place the case.
It will come before other judges. I will not feel it.
Yes, that is it.
So great.
Next.
Item 54.
Yeah.
All this matter on Thursday. Thursday.
Not the present case.
No.
Previous.
But he said seniority 53.
But they have
Instead of 2, they are fixing it to 4.
Mr. Rath, you have daily. You tell him, because otherwise he will have other matters where he will engage. You ask if he agrees, well and good.
No, I'm with him. I'm with Mr. Rath.
Only.
Yes, he is along with Thursday. No, Tuesday. No, let it go Tuesday.
Thursday. He wants Thursday.
Thursday. Thursday, I have a tribunal and I have a better.
Second.
Tuesday, what the problem is Tuesday?
Thursday.
They want that.
He is saying he has some difficulty.
So 9th? On 9th?
Tuesday.
They want that this should be, I have no objection to any bench, any judge. Because
he is avoiding the court.
No,
He said.
9. I am not avoiding anybody.
I'm still on the flip side.
I am. What you are saying?
Yes.
Sorry. Let me discuss. I will start better. Let me start now.
Yes.
I am ready with the case.
You have to be kind to the judge also.
No, because this first person I don't like them. With do humiliation.
This is what his client has instructed him. He is instructing counsel as instructed the senior advocate.
Counsel cannot give a aspersion against the other counsel. This is not expected.
Be prepared for the reference now.
Your Lordship fixed up it.
Yes, call this matter. If I post it before other judge is likely to say let it go before Dixit because I have already treated one subject.
Lord, I humbly pray let it be there.
Tuesday.
Yes.
Not this Tuesday.
Tuesday, Your Lordship is not there.
Then
Therefore, I told Tuesday.
Let it be on 9th.
I have no choice.
Let it be on 9th.
9th, we have difficulty. We have questioned many matters. On
11th.
Yes, Mr. Mohan.
11th.
11. This 11.
Yes.
January 11.
January 11.
11 I have a problem.
Because I love I am on leave.
January.
One whole week I am on leave. Because of some programs. Yes.
Exactly New Year.
If you want before other judge, I will post it.
No.
It will be there. Next.
Item 54.
54.
54, I am for the applicant, my lord. Yesterday this matter was there. My senior submitted that since post gets granted and disputes with regard to intercept dispute of petitioner vis-a-vis opposite partner 5 and second post holder was involved in a criminal case and abscond.
Still it is pending.
No,
He is not available at all.
he is not available. Is by senior submission that he will be adjusted in second post.
Correct.
And
You
I
will be
adjusted. And accordingly, my lord directed to write a memo. But I've seen the memo, my lord. Is if my lord will see this type of memo, my lord, I may not be because here it has stated.
You rate me.
Yes.
I give it to you.
Let it be also on merit be taken off if they will not.
Now it's not possible.
Any date, my lord.
In the February 2nd week.
Lordship, it's a small issue.
It will anyway.
One point, my lord.
No,
for third post, it is a litigation.
Yes.
He has been appointed by relying appointment order as against the fourth post.
No.
Can you overcome that? That the appointment letter says he has been specifically appointed against the fourth post. By relying that, he has claiming that I will be the third post holder.
Therefore, I suggested. I suggested.
And there are also other things.
In the event that person comes and you are disturbed, you are entitled to move an application for reopening this case.
No, that's yesterday my lord stated with regard to
What you are not agreeable with that proposal?
he has stated he has stated that he will be adjusted against second post and he will receiving granted of third post. And I will be adjusted against third post. After his adjustment, I will get granted. And in one hand, he is saying that post gets granted. If he will be adjusted against second post and receive
the granted of second post itself.
Exactly, my lord.
Your Lordship, no, Lord. I am just coming to. Your Lordship kindly
I will not get nothing.
granted only second and third post is eligible.
Correct.
My lord, kindly appreciate. I have already been approved against the third post.
Yeah.
I have received salary for 3 or 4 months.
Yeah.
My lord, here but in the event I will be adjusted against the second post, certainly from the date of adjustment I will be entitled to. Then I am just coming to. Therefore, I pray from the date of adjustment, he is the fourth post appointee, because appointment is this, and also the governing body resolution of 98. These are all 97 appointee. 98 and 2008 resolution, 2009 resolution says confirming my service against third post and his service against the fourth post. That has not been challenged at all. And even own appointment as against the fourth post, that has not also been objected by the appellant. How the question does not arise. Therefore, he may be adjusted from the date of adjustment. He will receive salary against the third post. And in the event, it is very remote possibility.
That is a remote
possibility. But if at all he will come, then I will go to the third post. He will go to the fourth post. If he will not agreeable, then I am ready to place the matter on.
Madam, may I pray any date first week of January for final hearing?
First week of February.
Madam, may I pray 661 of 2018. Another case has been filed by the appellant, which
this matter along
with that.
Give them.
May I pray, a small issue, because the 5 documents which he relied, that has not been controverted by him. They are confined to fourth post. Therefore, the question of arising third post does not arise. A short period it can be concluded.
You corrected now.
I am given, my lord.
661 of ICE. He has filed. That is not within my knowledge. Yesterday I came to know. If it will be compromised, then that will also. Therefore, I pray, my lord, your lordship, on the day of availability, any day, your lordship, I will take only 5 minutes. It will be concluded.
After my completion.
Yes, you may take the more time, but only
ultimately it needs 1 hour.
No, it will not take, because the one document he cannot overcome that.
Put it on 56.
On a short date, your lordship period, it can be also. There is possibility, he can also be in that way get the benefit.
29th. Yes.
29th minute?
Yeah.
February.
January. No, January.
February 29th.
You will not have 29th every year. Only once in 4 years will.
Only my lord will be pleased to, my lord. May I pray December any
December, very. Really.
Let them try the luck, my lord. Let them
try. If you try your luck, my luck will be spoiled. That is the reason. We will have it
any day, my lord.
Entry mode to continue.
Entry mode.
But that's why I'm getting salary still. They
will finish up.
But I have also come up with a stay vacation petition. That is why I am paying any day, Malad, in 15th, 16th or 17th, 18th, whatever that.
Second week of January. Second week of January. Instead of 29th. Yes. Okay.
Date may be fixed.
Yes. Put some date. Last one. This is over. Okay.
Last one was the personal appearance that was in the first.
That's over, no?
That's over.
Okay.